Good morning and welcome to the Public Service Commission of South Carolina. We are here this morning in a proceeding involving docket number 2022-360A. It's the review of Chapter 103, Article 4, the Gas Systems South Carolina Code of State Regulations. It's basically the PSC regulations pertaining to natural gas utilities. Let's take a roll call of commissioners. With us virtually, we have Commissioner Irvin. Present in the hearing room, we have Commissioner Justin Williams, Vice Chair Powers, Commissioner Thomas, Commissioner Carol Lee Williams, and Commissioner Caston and Chair Belser. I'll recognize our staff counsel to read the docket.
Thank you, Madam Chair. Good morning, commissioners and parties. We are here today for the proceeding in docket number 2022-360-A regarding gas systems. Chapter 103, Article 4 of the South Carolina Code of Regulations. All interested members of the public and the regulated community were invited to make oral or written comments on the proposed regulations at this public proceeding before the Commission. Proceeding has been scheduled for today, April 25th, 2023 at 10 a.m. Madam Chair, I believe all parties participating in this matter are available and the docket is in order. Thank you.
Thank you, Mr. Winburn. Let's take appearances of the parties, and then I'll kind of give the lay of the land of how we're going to proceed. Dominion Energy, South Carolina.
Good morning, Chair Belzer, members of the Commission. I'm Chad Burgess. I'm in-house corporate counsel for Dominion Energy, South Carolina, and with me today is Michael Anselmo. He's the corporation's outside counsel from the law firm of McGuire.
Thank you. And I know it's going to be hard. Here we go. We got a microphone coming. Piedmont Natural Gas Company. You can either use the wireless mic or go to the podium, please.
Good morning, Madam Chair. My name is Jim Jeffries. I'm with the law firm of McGuire Woods. I'm here on behalf of Piedmont Natural Gas today, along with Mr. Jason Richardson, also of the law firm of McGuire Woods. Thank you.
Thank you, gentlemen. South Carolina Public Service Authority, also known as Santee Cooper.
Hello, this is Steve Poucher here. Morning.
Good morning and welcome to the proceeding. And Duke Energy Carolinas and Duke Energy Progress.
Good morning, Madam Chair, members of the Commission. Frank Ellerby, the Robinson Gray Law Firm, appearing for the two Duke Energy entities this morning.
Thank you.
Thank you.
Southern Environmental Law Center, Upstate Forever, and Friends of Beaver Dam Creek.
Hello, Madam Chair. I'm Frank Holloman. I live in Greenville, and I'm a senior attorney at the Southern Environmental Law Center.
Thank you. I'm going to mess up this name, and I apologize. Niskanen? I'm not sorry. Can somebody help me with that? Attorney Gibson, are we present? The Niskanen Center.
Hi, good morning, Madam Chair. This is Megan Gibson on behalf of the Niskanen Center. I just wanted to note, I think those of us online are having great difficulty hearing, so apologies.
Thank you, ma'am. I appreciate that. And can you tell me again how to pronounce the name of your entity?
Yes, ma'am. Niskanen Center, the Niskanen Center.
Thank you. South Carolina Office of Regulatory Staff.
Thank you, Madam Chair, members of the Commission. Ben Mustian on behalf of ORS.
Thank you. For those of you online, I will try to remember that there can be a little lag between what's going on here and what you may hear, and that there may be a lag from what you say and come back to us. And so I remind myself as well as all in the hearing room of that little delay there. This is a rulemaking proceeding that we are conducting pursuant to the South Carolina Administrative Procedures Act. There have been a number of comments filed in the docket. Those comments are before the Commission for consideration, as well as comments we receive here today through witnesses or attorneys. We have several public witnesses who wish to be heard this morning. We will hear from them first. You will have between 3 and 5, up to 3 to 5 minutes. We need to allow everyone opportunity to speak, and we've got a lot of ground to cover this morning. It will be timed, and we will ask you to cease at no more than 5 minutes. If you have pre-filed or filed comments already and you're a public witness, please know that those comments are available to the commission for consideration, as well as what you may say today. Once we finish with the public witnesses, there are some legal issues that parties have raised. We will entertain oral argument from attorneys on those legal issues. And then we will go through each of the suggested regulation changes that are before us. Anybody have any objection to that procedure this morning? Okay, thank you. It's kind of a dangerous question to ask, but I asked it anyway. With that, I'm going to recognize our executive director. We've got to get some jurisdictional documents into the record. Let's go ahead and do that before we begin with the public witnesses.
Good morning. Good morning, Madam Chair. Can you hear me?
Yes, ma'am. Good morning.
So we will start with distributing the documents that I filed with the Legislative Council, beginning with the notice of drafting.
Ms. Boyd, are we going to make this a big composite exhibit, or do you want them entered separately?
I think a big composite exhibit is fine, Madam Chair. These documents have also been posted on the docket management system.
Okay, so we have the notice of drafting.
Yes, ma'am, the notice of drafting, and Ms. Wilson is kindly helping us this morning. She is providing you with the original document transmittal form and the notice of drafting, and also an official file stamp copy of the document transmittal form for the notice of drafting, which
Okay.
is stamped November 9th, 2022.
So we're gonna have one big
Yes, ma'am.
composite exhibit of
Yes,
all of
ma'am.
these documents.
Yes,
Okay.
ma'am, unless you have a
No,
problem.
no, that's fine. I
All
just want
right.
to make sure.
I will proceed.
Yes, ma'am.
All right, the next document Ms. Wilson will distribute is the proposed regulation that was filed with the Legislative Council on January 13th, 2023. And including the official file stamp copy of the document transmittal form, also dated January 13th, 2023. Next, Madam Chair, Ms. Wilson will distribute the notice of drafting and the proposed regulation, copies that were published in the South Carolina State Register. And the last document of the three that she will be distributing here shortly includes the text of the regulation. There's a link in the proposed regulation that was published in the State Register on January 27th, 2023, and that's the third of the three documents that she is distributing now. Finally, Madam Chair, Ms. Wilson is distributing copies of the verifications from the two versions of the proposed regulation. One is a clean version, meaning it does not include any underlined language or struck language. And one is the clean, one I just said is the clean. So there's no underlining, no stricken material. The other document actually includes underlined and stricken material. And what we have to do, of course, is review the proposed regulation before it is published in the state register for changes. So that's the last document that she published. And that ends the exhibits, jurisdictional documents for this morning.
Thank you, Ms. Boyd. We will mark those jurisdictional documents as Exhibit 1 and receive that into the record of this case. The notice of drafting, the stamped copy of the notice of drafting, the proposed regulation filed on January 13th, 2023 with a stamped copy showing that the filing with the Legislative Council, the notice of drafting as it appeared in the State Register, the proposed regulation which appeared in the State Register on January 27, 2023, and the verification of the proposed regulation, one clean version, one version with underlined and stricken language to indicate changes. Is that correct?
Yes, ma'am.
Any parties need any of those copies? Okay, hearing none. Okay. Thank you very much, and we will begin with hearing from our public witnesses. Ms. Boyd, if you
Yes,
would
ma'am. We're ready
introduce
to
it.
proceed. I see on the document that was published on our docket management system that Attorney Holloman's name appears first. However, he is present and appearing as an attorney, so I will move on to Ms. Leonard. I do not see her name. She's supposed to appear virtually, but I don't see her name just yet. However, Ms. Gibson, Ms. Megan Gibson is available online, and she will be your first public witness.
Ms. Gibson, can you hear us?
Yes, ma'am. Good morning.
Good morning, Ms. Gibson. We can hear you, and we have you on the screen. Please feel free to go ahead with your comments. You have 3 to 5 minutes, no more than 5 minutes, please.
Yes, ma'am. I will not go over. And I would just note again that those of us online are having much difficulty understanding what's being said unless the speaker speaks directly into the microphone. So apologies if I miss anything or there's a delay if you have a question. So good morning, all. My name is Megan Gibson. I'm Chief Counsel with the Niskanen Center, a think tank and advocacy organization with a strong interest in securing Americans' property rights. So at Niskanen, we represent landowners affected by pipelines and fossil fuel infrastructure development throughout the country in both court cases and administrative proceedings. Niskanen applauds the Public Service Commission's efforts here to revise its regulations, especially with regards to regulations that impact landowners. The Commission's commitment to transparency is of the utmost importance to ensure that all stakeholders, but especially South Carolina landowners, have meaningful access to and can participate in the Commission's pipeline process. So it goes without saying that landowners face something that no other stakeholder does in pipeline development, the potential permanent taking of their land, even their homes, sometimes their livelihoods. And so despite these incredibly high stakes, landowners face an overwhelming number of obstacles throughout the process, from beginning to end, often with little to no resources, guidance, or legal assistance. The Commission should seize this opportunity to rethink and revise this broken process. So to that end, Niskanen fully supports the proposed revised regulations, which will help foster basic fairness to landowners and transparency in South Carolina's private gas pipeline development and approval process. It's high time for fundamental notice and transparency measures to be adopted in South Carolina to ensure at the very least landowners affected by pipelines understand the basics, namely who is seeking to take their land, what exactly they are seeking to take their land for, and what rights they have in the relevant process. The proposed regulations will do all of that, as well as greatly assist in correcting some significant wrongs committed against landowners by interstate pipelines in South Carolina. So by way of example, and I'm not going to go into extreme detail, because a lot of this will provide in our previously filed written comments, there are reasonable regulations enacted by other states that address many landowner concerns, and we provided 2 examples, and in both, each state regulatory body exercises more authority than what is being proposed here, including over the siting, the construction, and the operation of a proposed pipeline, as well as reasonable notice provisions that are similar to what we are talking about here today. So if other states have figured out how to ensure that landowners are informed and engaged in the pipeline development process, there's no reason why South Carolina can't do the same by formally adopting these very reasonable proposed notice regulations. So, for example, in Iowa, there are noteworthy landowner protections. Pipeline companies are required to give public notice even before they can apply for a permit, including public meetings presided over by the regulatory body in each county where real property or property rights will be affected, and they must include a summary of the legal rights of the landowners and distribute a statement of individual rights under Iowa's eminent domain code. Moreover, a pipeline company is required to provide 30 days notice by certified mail, similar to what's being proposed here, to every landowner of the public meeting, the details of the project, the landowner's rights, all under Iowa law. And similar to the proposed regulations here in Section B, a pipeline seeking rights under this chapter shall not negotiate or purchase any easements or other interests in land in any county known to be affected by the proposed project prior to the informational meeting. In other words, pipeline companies can't start going after people's land or start talking with landowners until people know what is actually going on. And that's what's also being proposed here today. In Ohio, last example, there are several pre and post application notice requirements for a pipeline company, similar again to what's being proposed here, including a public pre-application informational meeting no more than 90 days prior to submitting an app. The applicant is required to publish notice of the meeting between 7 to 21 days before the date of the meeting. The applicant is also required to send out a letter, again, to each affected property owner and tenant, similar to here, and at least 21 days before the meeting. The letter must include information, again, on how the landowners can participate in the certificate proceeding, a description of the project, and detailed contact information for the company.
Ms. Gibson, you've reached your 5 minutes. If you wouldn't mind wrapping up, please.
Yes, ma'am. I mean, you get the idea. And just in sum, the Commission should seize this opportunity to adopt these proposed common sense regulatory provisions to address harm that, as one landowner put it quite simply, should not be happening in America. Thank you for your thoughtful consideration and serious eye towards transparency. And please don't hesitate to reach out to us with any questions or concerns. We're here to help. Thank you so much.
Thank you, Ms. Gibson. Just hold just a second, please. Commissioners, any questions for Ms. Gibson?
Chair Belzer.
Commissioner Carolee Williams?
Thank you. Ms. Gibson, thank you for being here. I'd like to give you a chance to tell us a little bit more about the Niskanen Center. Where do you operate? Are you focused on a particular part of the United States? I appreciate that you brought us examples from Iowa and Ohio. And I'd like to give you a chance to give us some broader perspective if you have some to offer.
Thank you, ma'am. Again, I'm having some trouble hearing, but I think the question was, where else do we operate and potentially offer additional examples?
Yes, not in a nitty-gritty. You got the first part. Just what's the breadth of geographically of where the Niskanen Center operates? Where's your expertise? And then, without going into details as you did with Ohio and Iowa, can you talk more about, from other states' perspectives, is South Carolina the anomaly? Is South Carolina just like most of the others, and Ohio and Iowa are the only states that require the kind of transparency and communication that we are considering today? Did that help? And could you hear it?
Yes, I think I got most of it. Thank you. So the Niskanen Center is based in Washington, D.C., but we operate nationwide, and I, as an attorney, have represented landowners impacted by pipelines all over the country. Just to give you a brief laundry list, that includes in Virginia, West Virginia, Pennsylvania, New Jersey, Oregon, Louisiana, and Texas. And so we've seen how these types of processes play out and are implemented throughout the country. We chose Ohio and Iowa just to give two examples of what this looks like elsewhere. If it would be helpful to provide others in writing, I'm happy to submit more. But I'll say, generally speaking, that notice and comment periods are common throughout the country, state to state, but also at the federal level, when the federal government, via the Federal Energy Regulatory Commission, for example, is considering whether or not to approve a pipeline and give it eminent domain authority. And there, the requirements are incredibly stringent in terms of what the pipeline developer is required to do, what obligations it has in providing notice and informing the landowners, the potentially impacted landowners, of their rights, and both within the pre-filing proceeding as well as the application proceeding itself. One example that immediately comes to mind that recently happened in Texas that's similar to the Bill of Rights that's being proposed here to be handed out to each landowner is that Texas, in the winter of 2021, I believe, passed a bill which required common carriers, utilities, gas utilities to give landowners a Bill of Rights before engaging with the Texas process. So just another example for your consideration. Did that answer your question, ma'am?
Yes, it did. Would you say that South Carolina is typical in terms of its current requirements for transparency, or are we atypical?
I would say that South Carolina is a little bit behind the curve in terms of notifying impacted landowners for a proposed interstate pipeline project. In that currently, under the current regs, my understanding is that there is no real communication or communication requirement that's clear. So if under these regs, it would be abundantly clear who is trying to take their land, for what, and what their corresponding rights are, if they even want to engage with the process. Versus now, how are people supposed to even know what their land is that this process is ongoing, how to engage with that process, what is the proposed project, where exactly is the proposed project going? Like, very common sense questions that everyday people and landowners are going to have about a project. And it's just simply letting people know what's going on and how they potentially can, engage with the process if they want to. I think this is a very simple and reasonable proposal. In other states, if anything, pipelines have even more obligations, and state utility commissions have more authority and exercise that authority over how they approve a project and the corresponding obligations and requirements that the developer is held to in engaging with that process. So this is very, in my mind, incredibly reasonable, just common sense, if anything, just like an incremental first step.
Thank you, Ms. Gibson, for shining a brighter light on the subject. I appreciate it.
My pleasure. Thank you.
Commissioner Justin Williams.
Thank you, Madam Chair. Thank you, Ms. Gibson, for being here today. Could you point me to the legal basis you're using to support the commission has jurisdiction to address the issues you raised?
Sorry, I'm still having trouble hearing. Are you asking what the basis is for jurisdiction?
Correct. What is the basis for the South Carolina Public Service Commission to have jurisdiction for all the issues you just discussed?
So I believe, full disclosure, I am not a South Carolina licensed attorney. I am licensed in 4 other states. But under South Carolina Code, section, I think it's 58.5-210, the commission is, quote, vested with power and jurisdiction to supervise and regulate the rates and service of every public utility in the state, together with the power, after hearing, to ascertain and fix such just and reasonable standards. I want to highlight that word: standards, classifications, regulations, practices, and measurements of service to be furnished, imposed, observed, and followed by every public utility in the state. And I'm quoting directly from the code there, which includes, the public utilities include intrastate gas pipelines. So nothing in the proposed regulations changes anything with respect to eminent domain powers. I know that's been suggested along the way here. Rather, the proposed regulations are strictly within the statutorily authorized, quote, standards and, quote, practices, regulations that the commission has the full power to impose on gas utilities, all in an effort to make the process more transparent and fair to those most impacted by these processes, landowners. Does that answer the question, sir?
Yes, I have a follow-up question. So if the commission finds that it does not have jurisdiction, where would you expect to go next to make the arguments you've made before the commission?
Sorry, sir. Again, I apologize. If the commission finds that they don't have jurisdiction
To address the issues that you've raised? Where would you go next? What body would you go to next to address the concerns you raised?
Sorry, sir. I guess I'm just having a hard time understanding under why or how the commission would find that it doesn't have the inherent authority that is statutorily assigned to it to promulgate regulations and standards in its regulation of public utilities within South Carolina.
I think if you stay on the entire time, you may get more insight on that. My question to you, though, is if we find that we don't have jurisdiction, where would you go to next to advocate the position that you shared with us in South Carolina?
Well, I certainly hope the commission doesn't find that it that it doesn't have the statutorily assigned authority. That I very much think it clearly does, and if it finds that it doesn't have such inherent authority, again, I'm unclear as to how or why such a finding would be made, then unfortunately for landowners, I'm not quite sure what remedy, if any, they would have to just having basic awareness and notice of a utility that wants to take their land for a project. I'm not clear what the remedy would be there. And I certainly hope that that finding is not the conclusion of all of this.
Thank you for your testimony, ma'am.
Commissioner Caston?
Thank you, Madam Chair. Good morning, Ms. Gibson. Can you hear me okay?
Yes, though it's muffled.
So that was a yes, you can hear me okay?
Yes, sir.
All right, thank you, ma'am. I'm not sure I heard exactly. Is the organization you're represent, is it located in D.C. or are you located in D.C. or are both of you located in D.C.?
The organization is located in Delaware, or excuse me, that's where I'm from. So the organization is located in DC. I myself and my family, we live in the state of Maryland.
Okay. And I think you said something about it, but I didn't really understand. If you could, I didn't understand exactly what your organization does. Does it have a mission statement, or tell me in as few words as possible what your organization does?
Yes, sir. So we are a moderate, right-leaning think tank and advocacy organization. We are a nonprofit based in Washington, D.C., and our legal department, which I head, primarily focuses on property rights, landowner issues, and representing landowners in administrative and court proceedings throughout the country.
And did you say a right-wing organization?
Yes, sir.
Okay, sorry. Okay. Are you familiar with South Carolina condemnation law?
Sorry, sir, the South Carolina,
Condemnation law?
sorry, I'm having so much trouble. If you said common law, I am
No,
not.
no, ma'am. I apologize. It's my southern accent, I suppose. Condemnation.
Oh, condemnation law, and it was not your accent, sir. It's very muffled. Condemnation law, vague familiarity, but generally speaking, I'm familiar with how condemnation proceedings work in various states as well as at the federal level.
Is your organization's concern with just property right issues? Just gas lines going through property line issues? If it were a telecommunications, broadband, water utility, public or private water utility, would this still apply?
But I think I got your question. You're asking if the organization's concerns are beyond that of interstate pipelines. You mentioned broadband as an example.
Yes,
I just want to
ma'am.
make sure I have your
Yes,
question
ma'am.
right.
I mean, I'm trying to understand let me ask this. What are your concerns about the current extension or construction of the new pipeline process in South Carolina? In South Carolina only.
So I think I got that question. Again, it's very hard to hear online, but the concern is lack of transparency and notice and fundamental fairness for impacted and affected landowners. And I want to try to address what I think was your initial question, in that the organization doesn't focus just on pipelines. That's primarily what my work has been, is representing landowners throughout the country in various proceedings. And I've also spoken at the federal level on notice issues and lack of notice to impacted landowners. And we also work on transmission, electric transmission regulation, and there I have spoken on panels about similar issues and involving landowners and putting landowners on notice as a matter of best practices from the developer point of view. And frankly, it avoids potential for protracted litigation when developers come into a community and engage with the community in good faith from the very beginning versus hiding the ball and not telling them what's going on and what the plan is for their community and more specifically for their potentially impacted property.
Okay. I guess, finally, if the utility, this utility, any investor-owned utility in South Carolina or municipal, if it's found that they're complying with existing state laws, is that not satisfactory?
I'm so sorry, sir. We're having so much trouble hearing. So you asked if something was satisfactory.
Let me repeat that. If the utility is complying with existing state laws, is that satisfactory?
If the utilities abide, is the question, I want to make sure I have your question. If the utilities abide by existing state laws, is that satisfactory? Is that?
Yes, ma'am.
Okay. It's so muffled.
I apologize.
So I'm trying
I'm sorry.
very, very hard.
I said I apologize, and I'm sorry for that.
That's okay. We're making it work. I imagine this is just as painful for everybody sitting there than it is for us online. By satisfactory, if the question is, I guess I would ask what you mean by satisfactory, because from a landowner or impacted landowner's perspective, I could tell you horror story after horror story, especially when it comes to, for example, like an old elderly widow who lives by herself, and she doesn't know that a pipeline is going to be crossing her land, or even wants to take her land until they're on their property digging a hole or surveying her land. Or, what often can happen, and I think is addressed by the regulations as written, is land agents who are independent contractors, often of pipeline companies seeking to build this infrastructure, are incentivized to get landowners to sign the dotted line. And sometimes, I'm not saying always, but sometimes that creates a perverse incentive structure where the landowner is told a number of things to make them feel pressured to sign the dotted line, to give away their land, without even really fully understanding their rights, or that they have the right to an attorney, or they have a right, to not do what their neighbor did or the neighbor down the lane did, that they have some leverage to talk with the developer, with the pipeline company, and that they have certain rights in the process that especially, more vulnerable people, like, an elderly widow, I keep coming back to that because I've seen that time and time again, especially the most vulnerable among us, they don't know. They have no idea. And unless common sense notice provisions like that's being proposed here today or enacted, those people just get run over time and time again, from beginning to end in this kind of process. So just letting them know what's going on. That's all this regulation is proposing to do. It's nothing, in my mind, it's completely reasonable.
Okay. I have no more questions, Madam Chair.
Thank you, Commissioner Caston. Any further questions? Vice Chair Powers.
Thank you, Madam Chair. Ms. Gibson, I think a lot of what you're talking about would be in our section 28-2-10 and the sections after that, which is South Carolina's eminent domain law. that does not really come under our jurisdiction. I don't know if you're familiar with that. Have you had a chance to look at Section 28 of our law?
The question, I'm just going to repeat questions back to you to make sure I'm getting them right. So hard here. You're asking if I've seen Section 28, South Carolina's eminent domain code? Or
Yes.
Or if I've recently reviewed it?
Yes, that's my question.
Not any time recently, sir, no.
Okay, thank you.
Thank you, Commissioner. Parties, I did not ask if there were any questions of this witness. If you have any questions of witnesses, you need to get my attention before I begin with commissioners, please. Let's just make that clear. Ms. Gibson, thank you very much for appearing today in your testimony. You may stand down from the witness stand, and you're welcome to continue watching the proceeding on live stream. Thank you.
Thank you, ma'am.
Ms. Boyd, our next witness, please.
Yes, ma'am. Ms. Brooks Smith, can you hear me?
Yes, I can hear you.
Am I fairly clear?
Can you hear me?
Yes, ma'am, but I'm concerned about whether or not I'm clear on your end.
You are very clear.
Okay.
The previous speakers were difficult. Now I can hear the online people, as Megan just spoke, very clearly, but sometimes they're in the chambers. It's a little difficult, but I can hear fine right now.
Okay, the microphone is almost on my lips. That's how close it is to my mouth.
It's much better that way. Thank you.
You're welcome.
Ms. Smith, this is Florence Belser. I'm chair of the commission. You have 3 to 5 minutes, if needed, for your comments, and you may begin now. Thank you.
Okay. Thank you. First, I would like to thank the Public Service Commission for allowing me to speak today and for their intentions to enact changes to the approval process of new utility projects. As a landowner myself, I've struggled through this difficult process with the proposed Piedmont natural gas pipeline in September of 2020. I live at 25 Drummond Road in Travelers Rest, South Carolina, and my property was previously under consideration for placement of a natural gas transmission line. So I want to talk about my experience and what that was like as a homeowner. So after I received a letter from Piedmont Natural Gas on September 25th of 2020, I immediately contacted the consulting agency handling the surveys and discussed the contents of the letter. The agent then informed me that my land would be surveyed and led me to believe that I had no choice but to grant permission. My husband then contacted the agent and inquired if we were legally allowed to say no to the survey, and the agent replied in the affirmative, stating that we could in fact refuse the survey. Our attorney informed us that P&G must obtain a court order for survey after a 30-day waiting period. And this initial interaction reflects a lack of transparency that persisted throughout my experience and has been echoed by many of the neighbors that were involved in this proposed route. Simply informing me in the very beginning of my right to deny the survey would have been a show of good faith on the part of Piedmont Natural Gas. Sadly, similar events occurred with many of the landowners on this proposed route. Often they were told that the adjacent neighbors had already agreed and were fine with the pipeline, which was a falsehood. There were instances where agents stated that survey permission had been granted by a landowner's spouse when in fact it was not true. Several landowners misunderstood the pipeline to be a distribution line that would provide natural gas to their home, and the agents did not correct the misunderstanding. One landowner thought the line would be placed along the roadside in front of his home when in fact the route map showed the pipeline dissecting his backyard completely. One neighbor misunderstood the line to be a water line. And these are just a few examples of the numerous stories that were passed along from landowners, and they point to the necessity of providing accurate, consistent information to landowners affected by these projects. Within days of receiving my letter, I reached out to Upstate Forever, the Southern Environmental Law Center, and quickly retained an eminent domain attorney. I learned that there was no approval process required for these projects, and easement negotiations can proceed well before the public is fully aware of the project. Landowners must direct questions solely to the consulting agency whose lone objective is to efficiently and economically secure the necessary easement. I reached out to multiple state agencies searching for information regarding pipeline approval policies. Sadly, I surmised that landowners hold little power with regard to natural gas companies' use of eminent domain law. Without the knowledge and assistance of Upstate Forever, I would have not grasped the scope of the proposed project nor the impact to my land. In response, I was forced to go door to door in an effort to locate others on this potential route. We quickly became a group of 35 landowners, friends of Beaver Dam Creek, with the goal to inform one another and advocate for our land rights. We shared stories of our interactions with land agents, contacted our elected officials, and reached out to local media with the assistance of Upstate Forever. Each time we requested a public forum to discuss the project, Piedmont Natural Gas responded with, "We prefer to work one-on-one with landowners." This tactic of allowing negotiations to occur in the dark and away from public oversight places landowners at a clear disadvantage. Communication in a public setting ensures that consistent and truthful information is disseminated and also allows for the community to thoughtfully consider utility projects as a whole. In conclusion, I thank the Commission for their willingness to re-examine this process in which pipelines are proposed, evaluated, and approved. Landowners deserve to have thoughtful consideration and a say in their land rights. Thank you so much for hearing my public comments.
Thank you, Ms. Smith, and I'm aware that you also filed a letter, and that is before the commission as well. Commissioners, questions for this witness?
Madam Chair.
Commissioner Irvin.
Thank you. Thank you so much for appearing today and informing us about your concerns. I remember that 2020 situation because I represent Greenville and Spartanburg County on the commission, and as I recall, we ended up asking Piedmont Natural Gas, or I did, at a hearing, to please consider putting this pipeline in the highway right-of-way. Do you remember that?
I do, and I thank you for your intervention was critical in helping us.
Well, and to their credit, they did, in fact, decide to use the highway right-of-way, which makes much better sense than taking landowners' backyards and farmland, some of the most beautiful land in the state of South Carolina, right there in your neighborhood.
Yes.
So we did the right thing ultimately, and I want to thank Piedmont Natural Gas and their management and CEO for listening and doing the right thing. But your point, I think, is that it may not always be that way. And the next go-around, who's to say that someone will decide that this is important to protect landowners' rights and property rights. There's a lot of talk in politics now. We just want to be left alone. A lot of people just say, we're tired of government overreach. We're tired of folks trying to, take our guns, take our property, take away our right, to protect our land, lives, livelihood. A lot of these folks in your area are farmers, are they not?
Yes, and I have an organic farm on my property that we were in the process. That's why we had moved out to Travelers Rest to get some land, and that transmission line was going to be just right there beside all of that, and it was horrifying. And to your point, they did do the right thing, like if you want to call it the right thing, but if you remember, after our route, they then went on to another route that they proposed on other people's private land, and that they basically, that group came together and followed kind of a blueprint that we had set up. And so I think, yes, they eventually, landowners were successful, but I think if we had some guidelines, some information, I mean, the amount of effort it took, there were so many people that I spoke with that were afraid to even speak out for fear of some type of retribution when if in fact P&G did put the line in. And, Frank Holloman from Southern Environmental Law Center said, your best, the most effective way is to fight it, and you're not going to face that retribution. But yes, they did move, but it was really from community pressure and media, and we had to do so much that if we had gotten this information, it would have been so much more fairer to our landowners. Just as Ms. Gibson spoke, we had many situations with elderly people along the route who had, and I spoke with them personally, and it was, they really had no idea what was happening to their property. And so, I think that, what we're asking is, yes, you have to be careful about government intervention, but this is really about an opportunity to help individuals maintain their rights. So I really, pray
you make an excellent point, Ms. Smith. And here's the other thing. I bet maybe you could tell us if this is true, but there's certain residents that are really fearful to get engaged in what they see as a controversy. And a lot of folks in our state, unfortunately, have disabilities that prevent them from even getting involved. They may have other limitations, like their educational level is such that they may not really understand a mailer, so it gets compounded when you've got folks that are fearful that what is this all about? And
yeah, I mean, that's true. I think that is absolutely true. And if I had not been aware of these organizations like Upstate Forever or Southern Environmental Law Center, I would have had no idea really how to proceed, because I feel that landowners are at such a disadvantage with the information, because you're really dealing with this kind of consultant group. You can't, you can try and call. I mean, I called, Duke Energy, I called everyone, and they often don't, the people you speak with in customer service, they don't even know what you're referring to. And so, you're just at such a disadvantage to obtain information. And then by the time some people get that information, they've already started negotiating easements and had people sign before other people along the route or the community even knows what's going on. So it's has been an effective tactic that's been used by utilities, and landowners are just begging for some help to protect our land.
Well, let me thank you for all of your efforts, Ms. Smith, and all your neighbors that pitched in and helped.
They were wonderful.
Spread the word. And you know what you've done, and I want to put this in a larger perspective. Due to your efforts and the efforts of your neighbors, friends and neighbors, you have preserved one of the most pristine wooded pasture land, mountain view environments in our nation. And it would have been a shame and disgrace had that been disturbed simply because you didn't know what your rights were. And there's so many other people out there that, just like you, won't know when they come to take their land. And so I think it's a reasonable and fair and just regulation. When you talk about due process, it really comes down to notice and an opportunity to be heard, isn't that right?
That's right. And I think that, you know, these are like, as you said, these are very reasonable. I think and it's fairness that any person would want. And, you know, landowners are just at such a huge disadvantage against these big corporations, and they utilize that. And so, you know, I think that just, you know, there's a million other instances of this going on in other beautiful areas. And so it would just be wonderful if we had, you know, started out, as we said, with a community notice and a truly transparent community notice where people can really think about it. But you know, yes, I'm glad I was able to do what I could. That my neighbors were just wonderful, and we were at an advantage that many people that were adjacent to one another were family members, and that helped to build trust through our process. I don't know if it would not have been as successful if people weren't able to say, yes, you know, you can trust this person, you know, because you're kind of putting yourself out there. And as I said earlier, people were really afraid to speak out. And that was really sad to me.
Well, again, thank you for coming today. You know, when I was in Boy Scouts years ago, we used to go up to Camp Olinda, and I'm sure you know where that is. And we hiked those mountains, and we had scouts in there every summer for 12 weeks, and they loved it. They still love it. And there's a lot of historic significance to that area, too. I'm sure you know the story behind Poinsett Bridge.
No, I do not.
Well, Joel Poinsett, who was ambassador to Mexico, it was South Carolinian, and that bridge was named after him. It was the first road that connected upstate South Carolina with North Carolina. And it winds up through the mountains. You can still walk the old trail. It's just down from Camp Olinda on the creek there. But it's one of the most unique historic places you'll ever visit. I encourage you to go by sometime and look at it. But that's just one of many examples of how significant the history and the landscape are in your neighborhood. And I'm just so thankful that you stepped up and did the right thing. Thank you for being with us today.
Well, I'm happy to, and, you know, happy that I could contribute.
Thank you, Commissioner Irvin. Commissioner Caston.
Thank you, Madam Chair. Can you hear me okay? Ms. Smith?
Yes, I can.
Good, and thank you again for participating. Beaver Dam Creek, and I see where I think you said you were from Travelers Rest. Do you live near the Old Berry's Mill Pond by any chance, or is this another Beaver Dam Creek area?
Well, so I'm not sure. So I'm very close to the intersection of Ennery Road and State Park Road along Beaver Dam Creek. But basically this proposed route went, all of the properties were bordering Beaver Dam Creek. So I'm not sure, you know, where it actually concludes.
I understand. I guess for transparency, you know, I worked for a utility previously, and we actually acquired some property along Beaver Dam Creek and Berry's Mill Pond and different reasons. But what I was going to ask you, listening to your earlier comments, you had mentioned, I think one of the neighbors thought a water line was going in. And what I'm curious about, or what I'm trying to understand, is the issue, or at least your issue, with the way that the company pursued this or did this, or was it, if it had been a gas line, I mean a water line, would it have made any difference?
No, absolutely not. I mean, I think that it's not about what this, I mean, obviously you have more fear over different types of easements, but, you know, once the easement is granted, the utility can put anything on that in the future even. It's really, it's strictly about having your land taken. And for us specifically with this project, it was, because it was a high pressure transmission line, the easement was much larger, the width that would be required, and it was stated that the utility has to have access to that line, meaning that there could be trucks in your backyard at any time because it's their land now. And so it wouldn't matter whether it was, for me and for other people, whether, it was a water or a gas line or any other type. It's that your land is being taken, and you really can have people on your property at any time, and it dramatically affects the property value, I think. I mean, I wouldn't have purchased our land later if I had come, if this had gone in my backyard, right, very close to my garden. So.
Well, I understand and I appreciate it. That was very, very helpful. So it sounds like, if I'm understanding you, is in your opinion, the company did not pursue this well or accurately or honestly, but regardless of what it was going in, you simply didn't want anything going through your property. Is that a fair statement?
Absolutely. And I don't think that, I'm speaking for my group, but I don't think anyone, they didn't want anyone on their land. And I think, it gets back to what the motivation of the company is. Was this we didn't feel like there was any communication of why this was needed. What is this something that is being, done just for profit, or is this something that's a true need? There was no communication between landowners and Piedmont Natural Gas. It was basically this consulting agency that is, and they have their own motivation to secure the easements. Do you know what I'm saying? And so there was this missing, the information sent was just a simple flyer with very limited information on it in the beginning from Duke and Piedmont Natural Gas.
Yes, ma'am. I understand. And I will tell you this, just from personal experience. We did, at a utility I used to work, contract out with someone, and it didn't quite go the way we anticipated, and we just used one of our folks that pretty much knew everyone. They knew him, he knew them, and it went much better. But I appreciate it. Thank you very much.
Thank you.
Thank you, Commissioner Caston. Commissioners? Ms. Smith, thank you for your testimony this morning. You may stand down, and you may sign off or continue listening. If you continue listening, I'd ask that you mute. Thank you, ma'am.
Thank you.
Ms. Boyd, our next witness.
Chairperson, so the next public witness is Amanda McKay.
Ms. McKay, can you hear me?
Yes, I can hear you.
Good morning, Ms. McKay. You have 3 to 5 minutes. We'll cut you off at 5 minutes if you don't mind. So please go ahead with your comments. Thank you.
Thank you. Good morning. My name is Amanda McKay. I am the program manager for the Pipeline Safety Trust. The Pipeline Safety Trust is the only national nonprofit organization that focuses on pipeline safety. Our efforts focus on education and advocacy, increasing access to information, and building partnerships with residents, safety advocates, government, and industry to promote safe communities and a healthy environment. Thank you for the opportunity to speak today in support of the proposed natural gas regulations. The trust was formed following a 1999 Olympic pipeline failure in Bellingham, Washington. When the line ruptured, it spilled 250,000 gallons of gasoline into a creek in a heavily used city park in Bellingham. This entirely preventable failure and the subsequent explosion and fire stole the lives of 3 boys and damaged the city's water treatment facility, burned almost 2 miles of a salmon stream that runs through the center of our town. The families of the boys who died and the community at large successfully pushed for funding for the trust as part of the criminal settlement paid by the operator responsible for the failure, thus creating a public interest watchdog to improve pipeline safety across the country. Natural gas pipeline safety is incredibly important to the communities for which the infrastructure runs through. Explosions have the ability to cause thousands of dollars in property damage, take the lives of loved ones, and eliminate a sense of safety and security that people have within their communities. Since 2020, gas distribution and transmission pipeline incidents have killed 31 people, seriously injured 84, and cost the public over $49 million. In the same period, South Carolina has had 6 significant incidents on gas distribution and transmission lines, costing $1.7 million. In addition to the immediate public health and safety concerns around potential pipeline ruptures, the construction and operation of these pipelines can have a major effect on the environment. Natural gas emissions are a significant contributor to climate change, contributing more to U.S. climate pollution than coal. Communities have faced decades of exposure to methane and will continue to experience the effects of climate change. Regulations offer an opportunity for the consideration of environmental effects of projects that would not undergo NEPA review. The proposed gas regulations close this gap by requiring the basic considerations around the impacts to the environment, environmental justice communities, and that costs be taken into consideration. The trust also supports the provisions requiring more transparency about projects, including providing notice to property owners about proposed projects, informing them of their rights under eminent domain law, and requiring a public hearing about these proposed projects. Once again, these are common sense proposals that stand to benefit South Carolina communities. Providing individuals notice about projects, informing them of their rights, and providing an opportunity to be heard empowers the public, can help moderate conflicts, and promote safer communities. Thank you for the opportunity to speak today. If you have any questions, please feel free to ask them now or contact me at a later date. Thank you.
Thank you, Ms. McKay. Tell me where you're located.
The Pipeline Safety Trust is located in Bellingham, Washington, and that is also where I live.
I was just curious how you heard about this proceeding.
We have recently we've been able to expand our staff, and we have been able to do more monitoring of state rulemaking dockets. And so we became aware of this rulemaking and updates to the regulations, and decided that we would like to comment in support of the proposed regulations.
Okay, South Carolina's just a long way from Washington, so I was just curious. You mentioned 6 incidents in South Carolina on gas distribution lines. Were those natural gas lines, or were those gasoline petroleum lines?
Yes, there were 6 incidents on both gas distribution and transmission lines, and those would be natural gas.
Okay, just curious on that. Commissioners, any questions for this witness?
Quick one, if I may.
Commissioner Caston?
Ms. McKay, can you hear me okay?
Yes, I can.
So the name of your organization is Pipeline Safety Trust?
That is correct.
Is the focus on pipeline safety, or this I'm not saying this is what you said, I want to make sure I understand. Is it on pipeline safety, or is the organization primarily just against gas and petroleum pipelines in general?
So we are a national watchdog organization focused on pipeline safety. We have worked with federal regulators, large industry trade groups. We repeatedly work on the Pipeline and Hazardous Safety Materials Administration reauthorization. So we are focused on ensuring that pipelines across the country are safe for everyone involved.
Okay, so it's safety focused. Your organization is not against gas pipelines or petroleum pipelines. Is that correct?
We do not, at this moment, actively oppose specific projects. Our concern is making sure that pipelines are safe for the communities that they run through.
All right, thank you, ma'am.
Thank you, Commissioner Caston. Commissioners? Ms. McKay, thank you for your testimony, your comments this morning. You may stand down as a witness and you can sign off or continue listening. If you do continue listening, we do ask that you mute your microphone. Thank you, ma'am.
Thank you so much for the opportunity to comment.
It's early where you are. You had to get up early, so thank you. Ms. Boyd, our next witness.
Yes, ma'am. I think Ms. Newman, Betsy Newman, had to leave, and I don't see where Mr. Potty appears online. So your next public witness is in the hearing room, Ms. Megan Chase Muller, and she will testify at this podium.
Ms. Muller, please come up. Good morning.
Good morning.
And you can see the clock, so we'll let you go from there.
Does this microphone work? Okay.
I think it's on. Let me.
Okay.
Feel free to adjust it as you may need to.
Okay.
Thank you.
Hopefully I won't go crazy with it. Good morning, Chair Belzer, and thank you to the entire commission for the opportunity to participate in this hearing. My name is Megan Chase Muller, and I'm the State Policy Director for Upstate Forever, which is a land trust and conservation organization. We work to protect critical lands and waterways throughout the 10-county upstate region of South Carolina. The comments I would like to offer today are from the perspective of a community-oriented organization that often gets the first call when residents see issues with pipelines before, during, and after construction. When residents receive a notice from a utility that wants to build or expand a pipeline through their property, they often ask us what their options are or what the anticipated environmental impacts will be. And I think you saw that reflected in a previous person who just commented. Since 2016, we have worked with landowners on 3 different pipeline projects. Just hold that.
It's on. Go ahead.
Does this work? Okay.
He's going to raise your volume back there.
Okay.
Thank you. Go ahead.
We've worked on 3 different pipeline projects with landowners, 2 that fall under the Commission's jurisdiction, to address a litany of issues regarding lack of information and transparency, and in limited circumstances, even circumventing of property rights. It is my understanding also from last year's workshop on docket 2022-47A that it is best practice to avoid mentioning specific projects or situations that could come before the Commission in the form of cost recovery. So I wanted to be respectful of that and not mention specific projects. But I will note that some of these incidents have been communicated to commissioners in previous hearings, such as during the 2 generic proceedings for the gas utility construction dockets on February 2nd and 4th in 2021, and then more broadly during last year's workshop on 2022-47A. What these comments center on is that we've witnessed far too many incidents that leave landowners in the dark about the nature and extent of a proposed natural gas pipeline, and some where landowners were made to believe they had no option but to hand over their property rights. Even when utilities attempt to provide information to the public and hear their concerns, which is most often the case, it has been done in ways that are confusing, to landowners and their surrounding communities. For example, we've seen fact sheets sent to landowners that contain tiny 3-inch maps with multiple routes drawn broadly across farms and neighborhoods, making it virtually impossible to tell where those routes are going to go. And those fact sheets also didn't include justification for the pipeline as well, which frustrated many in the community. We've seen different notice letters containing different levels of information sent to neighboring households. We've seen community meetings held by utilities, which at first were very promising, but ultimately ended up being closed to the public and left participants with more questions than answers. And in the absence of full and transparent information, we ourselves have actually hosted community meetings that were open to all residents, not just landowners that received a letter from the utility. And we hosted those meetings so that they could interact with each other, find out as much information as they could, ask those questions directly, and communicate these concerns with their elected officials. I should note that we're not here to discuss the merits of eminent domain, nor do these regulations alter what is already set out in statute. But what we are simply asking is that before eminent domain proceedings begin on the construction of a pipeline, that the affected landowners are given the courtesy of knowing what their rights are, how the project will impact their community's land, water, and cultural resources, and the justification for the project. The regulations in Subarticle 9 proposed by Commission staff would provide a baseline of information sharing so utilities can provide the same level of information that landowners deserve to hear in a uniform and transparent manner. And by daylighting this entire process and answering questions on the front end, it could actually result in a reduction in the amount of disputes, reduction in the amount of frustration that we've seen from communities across the upstate region of South Carolina. We believe in the basic tenets of community trust, transparency, and public accountability in the decision-making that affects communities in the upstate. For this reason, we are supportive of all of the proposed regulation changes in Subarticle 9, and we know the Commission is fully committed to transparency as well, and we appreciate your consideration of these changes.
Thank you, Ms. Muller. Let's see if there are any questions. Commissioners, questions for this witness?
Chair Belzer.
Commissioner Carol Lee Williams.
Thank you, and it's good to see you again. My question as I listen to all of the testimony is, why is this question emerging for gas pipelines? Have we got the system right for other utilities, or is there something about the gas pipeline industry that makes it a different challenge? Answer that in whatever way you want, but that's what's going on in my head.
From my limited experience at Upstate Forever for the past 4.5 years, we have only received these concerns about the intrastate natural gas pipeline construction. We have not received the same level of concern about water utility lines, for example. Sewer is its own separate ordeal, but we don't see the level of concern and confusion when landowners receive these notice letters from a natural gas utility. And I think it's a limited scope of these intrastate natural gas pipelines that fall under the jurisdiction of the PSC, as opposed to ones that fall under FERC jurisdiction that do have a lot more transparency requirements, NEPA requirements, and so I think what we're proposing here in Subarticle 9 would better mirror, not completely everything that has to be done under FERC, but more aligns those processes to address the concerns on the front end, hopefully reducing the amount of frustration and conflict that we see in situations like this.
I think I got half of my answer. Okay. And it may be that there's not a good answer, but you know, that the question that I'm asking myself is, why is this a challenge in this circumstance when it's not with water utilities and it's not with electrical extensions? I mean, we have a siting act for.
Yeah.
So is it that we have provisions in place with other utilities, or, and you may not know, but
Well, I will say we do have a separate set of community members who speak up when a new transmission line for electric service is proposed, for example. But that's not what we're here to discuss today. We think that what is being proposed under Subarticle 9 addresses this one sphere of regulation that has gaps, that is presenting issues for information sharing with communities.
thank you very much.
Commissioners? Ms. Muller, Vice Chair Powers?
Thank you. Ms. Mueller, it is, I guess, another way of, I guess, following up on Commissioner Williams' question. It's transparency that's been brought up. Is that a real issue with gas companies or with gas pipelines that you don't see in other utilities?
I think I answered that question to the best of my ability from Commissioner Williams. I have noticed that there's more information provided from other electric utilities on their websites whenever they're proposing a new transmission line or something like that. And then they have regularly scheduled public meetings in the communities themselves to try to answer as many questions as they can. They have interactive maps on their website, and I think that those are provided as quickly as possible.
Would you think maybe part of the public's concern is that to put in a pipeline, there's digging, there's kind of a destruction of an area. Once a pipeline's buried, it's buried. Whereas with transmission lines, electric lines and all that, they're there and in the long run, I guess, more obtrusive. But you think the digging and the tearing up with the installation is a fear or a problem with the public?
Sure, and I think you saw those comments and fears reflected in some of our previous comments made this morning, where you have pristine, beautiful century farms that have not been disturbed, or forests that have not been disturbed for 100 years. And so when you have, I think in the absence of full and transparent information, it's natural for fear to grow, and anxiety to grow, and misinformation to spread within a neighborhood and community. So to the extent that you can provide as much information on the front end and assuage the concerns of community members, the more they're able to advocate for themselves, come to the table with the utility, propose some changes if needed, or ideally there aren't any changes that are needed, and it's a fine project and it doesn't have any real concerns. But in the absence of information that's shared on the front end, I can see how fear and anxiety and misinformation spreads. That happens with a lot of different situations.
Well, I served on the Coastal Council years ago with Brad Weiss, who I think was instrumental in creating Upstate Forever.
Yes.
And has done a lot of good work, and y'all have all done a lot of good work, but please give him my regards.
I will. Thank you so much.
Madam Chair.
Commissioner Caston?
I know Mr. Weiss too, consider him a friend, so give him my regards.
I will. He's out of the country right now, but when he gets back, I will let him know.
Well, tell him you bragged for him.
Okay.
I guess similar to the questions they're asking, because I was thinking in terms of this is a gas pipeline, period. But I was also thinking of, say, P&G and Greer CPW. They're a little overlap.
Yep.
And along the lines of what Commissioner Carol Lee Williams was asking is Greer CPW is not an investor-owned utility. They don't come before the commission. But does Upstate Forever or other groups expect the same thing, or is the same process involved?
I would hope that an entity like Greer CPW would also follow the same procedures that we're promoting today. But I will note that we haven't had any residents within their service territory come to us with issues like this. That's not to say that they don't exist, but they haven't come to us about that.
What's that expression? Hope is not a strategy. That being said, to your knowledge, is Greer CPW required to do anything beyond what they currently do?
I do not know.
I think that's it.
Okay.
Thank you, Ms. Mueller.
Thank you.
Thank you, Commissioner Caston. Commissioners?
Madam Chair?
Commissioner Irvin?
Good morning. Appreciate your being with us this morning, and it's good to have another Greenvillian with us. I assume you live in Greenville.
I do. Thank you.
And tell Brad Weiss that I send my best wishes as well when he returns from his trip. You know, he's demonstrated a lot of great leadership over his career, and I understand he's kind of retired now. Is that right?
He is what we refer to as a professor emeritus for us at Upstate Forever. Yes.
Well, you know, it's great to have folks like you and Brad that want to have an opportunity to be heard, and I appreciate you coming today. Thank you for your attendance.
Thank you so much, Commissioner.
Don't seem to have any other questions, Ms. Mueller. Thank you very much for your testimony.
Thank
today.
you all so much.
Appreciate it. Ms. Boyd?
Yes, Madam Chair. The next public witness is Mr. Patrick Wiley. He's appearing virtually.
Mr. Wiley, good morning. Can you hear me?
Yes, ma'am, I surely can. Thank you.
Good morning. We are ready to receive your comments. Please limit those to between 3 and 5 minutes. We'll respectfully cut you off at 5 minutes. Thank you, sir. Go ahead.
Appreciate it. It shouldn't take that long. I don't have a tremendous statement. I'm not from a particular conservation organization, just a private property owner in the state of South Carolina. I grew up here in Somerville, South Carolina. I grew up in Somerville, South Carolina. I'm living in Indian Land, South Carolina now, just south of Charlotte. But I grew up between Somerville and Edisto Beach. You're representing, I got a hat on for the Edisto Island Open Land Trust. I grew up hunting and fishing, you know, deer, duck, and dove throughout the entire state, and absolutely just fell in love with the outdoors, conservation, and everything that goes along with it. I have a strong belief in personal property rights. All the questions as to, you know, does this, is this law that's pertaining right now to natural gas pipelines, is it any different or than putting in a water gas line? It shouldn't matter. It shouldn't matter at all. This is still personal property rights we're talking about, while at the same time they are different things. And there's no reason that I can see that a different thing can't be governed differently. If you've got a landowner that's choosing to provide an ongoing, continuing service for not only a company that's trying to put a pipeline through it, but the community surrounding them, then that's a service that should be respected, not only going into the future, but before the conversation even begins. I don't understand where that disconnect is coming from. It's people's own property. You know, Ms. Megan Gibson raised some great points on why natural gas could be treated differently, you know, in that there are inherent risks, you know, from flaring, fuming, explosions, everything else that goes along with it, not disincluding the extra width that it needs in an installation of a pipeline. But being from South Carolina and growing up with the ideals that I've always had, it strikes me as, you know, it sounds like we're advocating, or the board is advocating just as much on the part of the utilities as they are for the landowners. And it's striking. I mean, I don't know, are we robber barons to our own state? Where are our personal property rights in this conversation? where are our environmental protection property rights of our local community? We should have more say in there. I mean, I'm just wondering how much of the South Carolina Public Service Commission authority is this panel willing to give away to these monopolistic entities, you know, that are allowed to maintain a monopolistic status or in one way or another. You know, I think she brought up that regulation, the code of 28-2-10 on that was brought up. Does that apply to the Service Commission? You know, it won't if you won't let it. It won't if you don't demand it. It won't if you give it away. We've seen Ms. Brooks Smith had some amazing stories that are shocking how these public monopolistic entities, publicly traded in many cases, are allowed to do literally whatever they want to, say whatever they want to individuals along a block, along the street, and everything be different. And, you know, say what they need to say. Oh, these people have already signed up. You know, it's something that's affecting their community, their street, their road. How they can literally, if they can achieve what they want, literally by whatever means necessary, then they've got to be held to a certain basic set of rules and regulations. And if this is a landowner's property list of property rights that they are inherently immediately given once they are even considered for putting in a gas or any sort of pipeline whatsoever, then that should be something that can be adopted, and it sounds like it can easily be adopted in letting this move through with this subsection 9. There need to be protections for public or private property rights. You know, why did Ms. Brooks or Ms. Brooks Smith, all of her neighbors, why did they have to waste their time in this conversation? Why did they have to group up? Why did they have to create this organization to band together in the first place? I'm sure they would have been doing a lot of other, walking their community in their beautiful upstate. My mom grew up in Greenville, South Carolina. My grandma and grandpa lived there, right next door. I don't know if y'all remember Mr. Preston Reed, an attorney up there. He and his 5 boys that all went to the Citadel were great friends of mine. And they are also quite large advocates of their community. But beyond that, this is not government intervention. This is government protection that we're talking about. Protection from these private, publicly traded companies that are given a monopolistic status. That's about all I've got. But,
thank you, Mr.
I'd
Wiley.
love to take some questions.
Thank you, Mr. Wiley. Let me see if there are any questions. Commissioners, questions for this witness? There don't appear to be any questions, Mr. Wiley, but I'd like to thank you for your comments this morning. You may shut us off, or you can continue listening. If you continue on the web, I do ask that you mute your microphone. Thank you, sir.
Absolutely. I'd love to continue to hear on. That was very interesting. Thank you.
Have a good day. Thank you. Ms.
Madam
Boyd.
Chair, the next public witness is present in the hearing room, Ms. Bonita Clemens.
Good morning, Ms. Clemens.
Good morning, Chairman.
Thank you for being here this morning.
Thank you. Thank you so much for allowing me to be here. My name is Bonita Diane Clemens. I was born and raised in South Carolina, particularly the big city of Iva, South Carolina. Any Iva people here? Anderson County. Iva is in Anderson County. Born and raised again in South Carolina. Attended Benedict College and USC, which are 2 of the great institutions in South Carolina. And I am a farmer. And I teach and train Black women how to grow food, because I feel that we all eat, and we all need to learn other ways to feed ourselves. So what better way than to learn how to grow? My grandmother, who is 96 years old, challenges me to learn as much as I can and to protect the land in this state. And I do like to say, everywhere I travel, internationally and nationally across this country, I always say South Carolina is the best state to live in. And I say that because when I travel upstate, low country, And I just marvel at the beauty of the land in the state. It's very beautiful. And I'm here today to say I'm in favor of the regulations, to, as someone has said earlier, for transparency, so that we can know what's going on. I think it's important to have good communication so that landowners can know what's happening. I received a letter one time that one of the utility companies need to come on my property and cut some of the trees back from the wires, and it was a good thing, but when I got home, they had removed my compost pile. I think they felt like they were doing me a favor, but I was terribly upset. And it was just, it was compost. And so I can't imagine if someone is able to come on and do what they want to do or do what they feel like is best, you know, in the name of laying pipes or other lines. So again, I was so upset because I think they thought that they were doing a good thing by removing all this dirt or debris, what they thought it was, but it really upset me. And again, I just couldn't imagine if they had the right to just come and do things that that I didn't approve. So again, I'm here. The organization that I represent started in about 2001 called Diane's Call. And our, one of our missions is to be good stewards of this land, of the land and the state that we live in. And again, I want to say thank you for allowing me to say that we are advocates for the new regulations, and we hope that you vote for it.
Thank you, Ms. Clemens. Appreciate your comments this morning. Let's see if there are any questions for you. Commissioners, any questions for this witness?
Madam Chair?
Commissioner Irvin.
Thank you. Ms. Clemens, it's good to hear somebody from Iva, South Carolina speak. You know, you're too young to remember, but when I was fortunate enough to serve in the General Assembly from House District 7, I represented Iva and Starr and Belton and Honeypath, and a lot of good people in that neck of the woods.
Yes.
And I appreciate your comments about the importance of the land and teaching others about that. You know, that's commendable, and I commend you. What's the name of your organization again?
The name of the organization is Diane's Call, DIANNE''S, and Diane was my mom who passed away when she was 42 years old. She had a stroke, and so the organization promotes health and wellness.
Well, that's a wonderful legacy, and I congratulate you on carrying forward that work in your mother's memory. May her memory continue to be a blessing for you and your group. I really just wanted to thank you for your attendance today, and encourage you to keep up all the good efforts that you're doing to improve and support your community. Thank you, ma'am.
Thank you.
Commissioner Caston.
Ms. Clemens, I live in Clemson, so I've been to Iva.
Go Tigers. Okay.
About the size of the hometown I grew up in.
Yes.
Relative to, I guess, your desire to protect and preserve farmland, is that in essence what you really are looking for?
Yes.
So it's not just a gas pipeline thing, it's a anything. Would that be a fair statement? Or is it not? If it's not, don't let me put words in your mouth.
Repeat the question. Let me synthesize.
I guess what I want to understand is, although this is a gas pipeline hearing,
right?
You're primarily interested in preserving and protecting farmland and being notified if someone's going to be maybe doing something to the farmland or maybe adjacent to you or whatever. Is that a fair statement?
It's fair, but I want to add something to it. Yes. Also, land for those who are not educated about what's going on, and I'll say me, you know, this process can be intimidating. It is intimidating. A lot of people who are told about this couldn't come because they had to work, so they couldn't come and at least try to understand. And so now I'm going to try to be a bridge to help educate on, you know, what it feels like, what it looks like. But I also know that I'm going to say low-income areas and areas where there are more people of color, things like this happen. And so I want to talk, you know, don't want to try to say I'm speaking for everybody, but also to bring awareness to those groups also, the farmland, and for those who don't have, can't take the time to come and talk about this, those who just don't know.
Yes, ma'am.
So primarily farmland, yes, but also those communities who need a voice.
I fully understand. And again, not trying to put words in your mouth, but it seems like it's not just a gas pipeline thing, but if utility wanted to build an electric generation or a solar farm or something on farmland, you would want to know.
I would want to know, but I am in favor of solar farms, but I would want to know.
I'm sorry.
Yes, I would want to know. Yes, absolutely, sir. Yes. Again, we were talking earlier about communication and transparency. I think everybody here has been in a relationship, whether it be with your spouse or your kids, and communication has been the number one, the key component to that relationship. Let's just have good communication.
I'm glad you mentioned that, Ms. Clemens, because it allows me the opportunity to let you know
yes,
that today is my 42nd anniversary. Today. And we communicate perfectly all the time, and we have for 42 years.
And that's been one of the keys, right? The key.
Without question. Thank you, ma'am.
Thank you.
Commissioner Williams? Justin Williams?
This is a bit awkward for me, so bear with me holding the mic like this. Thank you for your testimony. Thank you for coming today. Thank you for your work in agriculture. It's very important, and I appreciate it. Also want to acknowledge your concern. I'm familiar with environmental justice issues, what happened in the Spartanburg area, and how the Regenesis Institute and the Regenesis Project helped clean that area up. What's happened in Warren County in North Carolina, how PCBs were sprayed on the road, and there were protests to not have a PCB landfill put in that community, and the issues that arose from there. Understanding how overburdened communities seem to suffer more from environmental pollution and the placement of toxic substances and infrastructure. So I just want to let you know, I understand and I get the issue. My concern is whether or not we are the appropriate body to address the issue. Everyone who has testified here today have made very valid points. And I've never been a lifeguard, but it reminds me of being a lifeguard and watching 10 people drown and deciding which ones to save. Because you can't save them all. You can try, and you may die yourself. And so for me, as I listen to the testimony and go through the law, every point that has been made thus far, and I imagine every point that will be made after your testimony will have a certain level of validity. But ultimately, one of the things we would need to decide is whether or not the law allows us to implement the regulations that have been proposed. And I just want to thank you for your testimony and make those acknowledgments.
Thank you.
Commissioners, anything further? Ms. Clemens, thank you for being here today and your patience. I know it's taken a while to get to you, and you were here when we started, and we appreciate your patience and especially appreciate your comments. Thank you very much.
Thank you. My grandmother taught me to always be early. She's 96, still driving, still working, so I do what she tells me to do.
That's a good lesson that we could all heed. Thank you, ma'am.
Thank you.
Are we okay? Does anybody need a break? Miss Joe, you okay? That's not reassuring. We've been going a little over an hour and a half, and Miss Joe looks like she'll soldier on, but her expression tells me she could use a little break. That's our court reporter. So let's take a 10-minute break. We'll return at 12 noon. Thank you. Good afternoon and welcome back to the Public Service Commission. We are continuing in the proceeding in docket 2022-360A, which is a review of Chapter 3, Article 4, the regulations of the Public Service Commission related to gas utilities. Before we take our next public witness, I have a question for the parties. Mr. Pelfrey, are you, Mr. Pelcher, are you on the line?
I am.
Okay. Counselors, what I want to ask is, we've got a 3 o'clock special call business meeting today that we need to probably break no later than 2:40, 2:45 to give the folks in the back an opportunity to reset for that meeting. Are y'all okay pushing on through lunch, or because that's going to take a bit, and then we've got to come back, and I need to finish by 5 today. We do have tomorrow reserved, but do y'all want to keep going, or do y'all want to take a lunch break? Mr. Ellerby.
I'm fine. We'll push it forward.
Everybody's okay with keeping going? Okay. Thank you. If you need a break, let me know, but we're going to keep going through the lunch break. Okay. Thank you. Our next public witness?
Yes, Madam Chair. Ms.
Oh,
Edith-
excuse me. I need to roll call of commissioners. Commissioner Irvin, are you with us online? Commissioner Irvin and President of the hearing
Yes,
room.
ma'am. I'm present and accounted for.
Thank you. Thank you, sir. We have Commissioner Justin Williams, Vice Chair Powers, Commissioner Thomas, Commissioner Carolee Williams, Commissioner Caston, and Chair Belser. Now, thank you.
All right. Thank you, Madam Chair. The next public witness is, Ms. Edith Taylor, and she is President of the hearing room.
Good morning, Ms. Taylor. Thank you for being here today, and thank you for your patience. I know you've been waiting for a while, so thank you very much. You've seen some of the other witnesses, and you have 3 to 5 minutes for your statement, and then there may be questions. Thank you, ma'am.
Good morning. Thank you, Chairperson, and all of those in your prospective positions. I ask that you bear with me this morning. I am nervous, but I wanted to be here. Hopefully I'm representing, along with myself, any and all that have been placed in the situation that I have been with the oil company, gas company, with the position of lack of transparency and lack of credibility. I was contacted by an oil company, gas company, excuse me, when they were bringing the gas line down to Eastover. Well, let me take a step back. I'm sorry. I am from Richland County. I reside in Eastover, grew up there. I'm now in Hopkins, the big town of Hopkins. I was contacted by the gas company when they were bringing the gas lines down to Eastover, and they informed me that they had 2 gas pipelines on my property, which I was not aware of until this particular time that I was contacted. I am a widow. I lost my husband, who the property was really in their name, and now it's in me and my children's name. So after being contacted by the gas company, no transparency, credibility before this time, they informed me that they had the gas lines there, and they explained to me how they would compensate me for having the gas lines there, and was telling me it's been there since 1981. So when they informed me of all the information that they were giving me, I told them that I would rather seek an attorney before I move any further. They told me something to the fact that they needed to contact me back. Let me make sure we're on your property now. Let me contact you back. I'll contact you, gave me a week later, and they did contact me back, stating that they made a mistake, that they thought they were on my property, but they are not on my property. I have found out that they are on the property, no easement on the property, lack of transparency, lack of credibility, that they have been there, as they stated, since 1981. I am not being compensated, my family, for them being on the property at all. I have information showing that they are on the property. I've sought attorneys to try to move forward with getting some type of compensation for them being on the property. And I have had nothing but brick walls. I've contacted at least 5 attorneys, and they will agree to assist me. Then I won't hear anything from them. So I'm contacting them back. Well, yeah, I'm busy. I'm doing this. I'm doing some excuse. So I'm stuck in a limbo. No transparency, no credibility. Stuck in a limbo, trying to move forward when there's no place to go. I have no recourse at this time. I feel like any homeowner or property owner should not have this situation occur with them, not knowing where to go, even when you're trying to seek legal assistance, and that's falling through the cracks. So I'm standing here on behalf of anyone that I'm sure I'm not the only one that may have had this situation or something similar to this, but I'm standing here hopefully to have this situation rectified, that whomever, I've gone to Richland County seeking information that they might have, they tell me there's nothing. I've gone to the courthouse, they tell me that they can't find anything there. Every avenue that I have been able to work on my own, I've come up with nothing. So I just hope and pray that no other homeowner, property owner that has a gas or oil company on their property who's there, I would say, illegally, because we were not contacted. We have no paperwork, nothing to show that they're there. The information that I do have, I called the 811 company asking them to, I said that I was going to place a home there. It's not on the property where I'm living, where my home is located. It's on a different property that I own. And I told them I was going to place a home there. And when I, excuse me, when I stated that, they said, well, we need to make sure that there's nothing there, that the home can be placed there. So I told them I was placing the home exactly where they told me the oil line, a gas line, was located. When I said that, then I got the phone call from them. Oh, no, you can't place a home there because we have the gas lines there. So it's just a no transparency type of situation, no credibility that I find myself in, that I pray that no other property owner will have to go through what I'm continuing to solve or go through at this point. Thank you.
Ms. Taylor, thank you. Let's see if there are any questions for you. Commissioner Carol Lee Williams.
Thank you. I'm actually going to make a suggestion. I think that Ms. Dawn Hip is in the audience with the Office of Regulatory Staff, and they have a customer complaint support resource, and I might suggest that you talk with her about your particular issue.
Okay.
But I appreciate your bringing this to us and to our attention.
Thank you so much.
Commissioner Justin Williams.
Good afternoon, ma'am. Thank you for being here today. I apologize for you to have to be here for this. I understand the advocacy that you're offering, but what brought you here is what appears, if what you're saying is true, and I'm not saying it's not, but I'm just almost as a phrase of art. If everything I'm hearing and I understand correctly is true, it seems like you've been wronged. So I'm just trying to understand a little bit more about your particular situation. When you say a gas line is on your property illegally, whose gas line is it?
Dominion Energy.
Okay. All right.
Which before that, of course, SCE&G.
Okay. So Dominion Energy is on your property illegally. Is that what you understand?
That's my understanding.
Okay. Well, Dominion Energy is here. So the benefit, and it's so strange, I feel the need to bring this up. Whenever we have public hearings to talk about a particular issue, in this case we're talking about proposed regulation, we find ratepayers who have to use this process, which is designed to give comment about regulations and other processes which are designed to talk about rate increases and the like, we find people just like you, good people, who have tried everything that they know how to do to get help, but unfortunately have not gotten help, so they have to come here. I apologize for that. That shouldn't be the case.
Thank you, sir.
When did you first contact Dominion Energy?
As I stated, they contacted me when I was at a doctor's appointment, and I received a phone call from George Blackburn at Dominion Energy telling me of everything that I've been stating here, that they were on the property, told me about the since 1981 time, and that they had the second pipeline already there as well. And I was asking them, well, would I be compensated for you being there? Yes. And that's when I started saying, well, I want to get an attorney then. And that's when the ball was dropped. I did receive information in the mail, the little white docket telling us about that prior to, I believe, the phone call. But after speaking with George Blackburn, I have not heard anything, have not been able to contact them. The attorneys that I've been working with or tried to work with, they'll say something like, oh, well, the attorney that over Dominion, that was my friend. We went to school together. That's what one person told me. Just 2 months ago, I was in this attorney's office, and he was saying, well, who's the last attorney you spoke with? And I gave him his name. He said, let me talk with him. And he called the attorney while I was sitting there and was saying that I was there and seeking him as an attorney. Well, with him talking with the attorney told him that his son is an employee at Dominion. And at that point, I couldn't hear anything else. So I was just shocked to hear. Then now my thought is, well, that's why I'm here today, because I have an attorney that's not going to truly represent me as he's telling me he's going to. I paid him some funds to give me assistance, but right now he's just saying, you'll be next. You're next. Your folder's next, and this is the issue that I'm finding myself in, not being able to get an attorney because everyone seems to have a problem with wanting to assist me or represent me, because and one attorney actually told me, well, I know you don't want to go against Dominion. That's the big gas company. You don't want to go against a big gas company. So that's why I'm here.
Mm-hmm. When did your family acquire this land?
I was born in 1958. They acquired the land in 1957.
Okay. So well before to your knowledge, the gas line was placed there.
Right.
Okay. Are you sure that there was not any other agreement that you are unaware of that allowed the gas line to be placed on your property?
After speaking with them at Richland County, they were saying that there was never an easement on the property. That's why I'm saying that.
Okay. Have you who else have you contacted about this?
I went to the ombudsman office trying to get information there, and I couldn't get any information there. I've gone to another office in Richland County. I can't recall at this moment, but every place that I could feel like I might be able to get some type of information from. I believe property taxes at Richland County. I went there, and they're showing me a map that they say that they get from Google, and they're saying, but we can only go by what the map is showing us. Because I was trying to seek information. I've even paid for a plat for the property, because I felt like if I get a plat for the property, it's going to show that the gas lines are there, and that should settle the issue right there. I won't have to try to prove that the gas line, or I will have whatever I need to prove that the gas lines are there. Excuse me, paid this guy the money to go out there after finding out that the gas lines were there. And he came back and he says, the property on the plats that's at Richland County says it's only 16.8 acres. He came back with the new plat saying, I got you this plat. And he says, there's no gas line there. There was no gas line, but you take this plat down to Richland County as soon as you can. That's what you need to do. Take it down to Richland County as soon as you can. And instead of 16.8 acres, I have given you 17 acres. You have 17 full acres now. As soon as you can, get that plat down in Richland County. There's no gas lines there. No. And I knew he wasn't telling the truth. I knew he was not being honest with me. And I paid him this money. And now, which was $3,200, and I have a plat that's showing no gas lines on the plat, when in fact, the gas lines are there.
Okay. Are they above ground? When you say gas lines, I'm assuming they're above ground.
They're not above ground. It's just the big signs that are there showing that where the lines are, where they run, the danger, the octagon, I believe, shape. It's on a pole that's protruding from the ground.
Have you ever taken pictures?
Yes, I have pictures.
All right. Well, I find your story compelling. It's hard to believe. Maybe something inside me just doesn't want to believe that what you're saying is true, even though I'm not disputing what you're saying. It's just hard for me to believe that if what you're saying is true, that you would be put through all this trouble to try to resolve what should be somewhat of a simple issue.
Yes, sir.
Are you familiar with the DMS system here, the docket management system?
No, I'm not.
No. Madam Chair, I'm going to ask for your assistance. Once we finish this hearing, how long is the record left open?
5 business days.
Okay. It would help me greatly if you could upload some of your pictures and whatever information you feel appropriate to our docket management system.
Okay.
As I review what you present and consider all the evidence in this case. That young lady in the back, our executive director, I believe she's wearing, what is that?
Mauve.
This is mauve, Commissioner Williams.
Okay, I don't, and where I'm from, folks don't wear colors like that often, so I think you said mauve. Well, maybe my mother does, and I just don't know what it is. It looks pink to me, off pink.
It is. It's a shade of pink, so that would be appropriate, yes, sir.
Might also be called Dusty Rose.
Well above my color wheel. If you could get with our executive director, and I think she could walk you through how to upload some of these documents, because I think we should have the ability to at least see what you're referencing, and I think it will help us make a decision in this case. I echo Commissioner Williams's suggestion that you speak with Ms. Dawn Hip, or maybe even the ORS counsel here. Could ORS counsel and Ms. Hip raise their hands? I'm not saying that they can help you, but they represent the public interest, which among several different groups includes you. And I'm sure whatever they can do, they would do to help you out, ma'am.
Thank you, sir.
I'm sorry again that you're going through all of this.
Thank you so much, sir.
Commissioners, any further questions? Ms. Taylor, thank you very much for being here today, for your testimony, and for your patience. I know it's been a long morning, but thank you.
Thank you.
Have a good day. Thank you, ma'am.
You as well.
Madam Chair, the next public witness is Mr. Matt Neese, and he will be testifying or providing comments, virtually.
Good afternoon, Mr. Neese. There you are. Can you hear me?
I can hear you well. Can you hear me?
Yes, sir. Thank you for being here. Please go ahead with your comments. You have 3 to 5 minutes, and you may begin.
All right, thank you so much. I'll try to be brief. Most of this has already been covered by a lot of the great speakers already today. Just a little background about who I am and the organization that I represent. We are with Carolina Farm Stewardship Association. We are a nonprofit here in South Carolina that advocates for small and mid-sized family farms, growers and producers, and then also the food systems that a lot of these small farms sell to. We act primarily as a resource hub for farmers, not just with on-farm technical assistance and consulting, things like that, but also policy and advocacy work. And so we routinely poll and survey our member farms to kind of find out the policy gaps and issues that they face most. And top 3 consistently includes farmland conservation and concerns about disappearing farmland. We found that's not an issue not just for existing farmers who've been farming for decades, sometimes families have farmed the same farm for generations, but also new farmers who want to explore farming as a way of life. They want to try buying farmland. It's funny, it's harder and harder to find high-quality farmland they could farm on. And again, existing farmers may want to expand, they may want to buy neighbors' land, and they're just facing an ever-growing crunch of viable, high-quality, productive farmland. Farmers routinely face pressure from developers, both residential and commercial developers, eminent domain, and it's important to note, once high-quality farmland is developed, it's almost always gone forever. Once it's turned into a subdivision, once it's turned into any type of major development, it's then gone. And so we're here to say Carolina Farm Stewardship Association supports these new regulations as a means of giving farmers in farmland just an extra layer of protection, increased communication, increased considerations, just by requiring this communication between utilities and communities regarding any potential impacts. We found that in recent months and years, we're having to get creative with farmland conservation efforts. We work with the legislature, we work with private groups, because it is a complicated issue, and farmers' voices often are lost in the mix, especially with these small and mid-sized farmers. They're busy farming. They don't have time to attend commission meetings, and they don't have time to go and write their councilman or meet with their congressman. So we're here to kind of lend our support and lend farmers' voices in support of these new regulations. So thank you for letting us speak here today.
Just a moment. Mr. Neese, thank you for your comments. Hold just a second. Let's see if there are any questions for you. Any questions for this witness?
Madam Chair.
Commissioner Irvin.
Thank you. Mr. Neese, good to have you with us today.
Happy to be here. Thanks for having us.
Is your group or entity, did you say it's a nonprofit?
Yes, sir. It's a nonprofit. We're Carolina Farm Stewardship, but we don't specify which Carolina because we're based out of technically both. I'm the South Carolina policy coordinator, so I live and work here in Columbia, but we cover both North and South Carolina.
Very good. I think I read not too long ago that agriculture is still the number one business in South Carolina. Is that your understanding?
Yes, sir, it is. That includes forestry. So if you want to get very technical, they call it agribusiness. So agribusiness includes agriculture and forestry. Yes, sir.
And it's an important part of our state's economy for sure. You agree with that?
Yes, sir, and it has been for as long as it's been a state.
Exactly, and even before, even prior to becoming a state. Would you agree?
Yeah.
They were growing indigo down in the Low Country, I think. Right?
Yes, sir. Well, and in fact, before I used to work at CFSA, I used to work at the Department of Commerce under Bobby Hitt. And one of the things we would like to highlight to people is that for 2 centuries, South Carolina was really known for what they call the 3 Ts, tobacco, textiles, and tourism. That's it. It's not until recently when you've had groups like Boeing and BMW and Volvo come in that we started to kind of diversify and modernize our state's economy, which is kind of the issue, is because when you build, a 1 million square foot spec building on farmland, that's it. There's not going to be a lot of farming done on it.
That's a great point. And I'm wondering, have you tried to work through the South Carolina Department of Agriculture as a resource. Is that someone that you all are in touch with?
Oh yes, sir. We work with SCDA almost daily. We work with Farm Bureau all the time. And again, Farm Bureau, they're about to launch their new trust, which is going to be a great resource for farmers. Just last week, we were over at the State House. There's currently a working lands conservation bill making its way through the State House designed to, again, just give farmers more choices, more communication, because we've got farms in the upstate where a developer will come in and say, we'll cut you a check to buy, a 7-figure check for your farmland. But this is a century farm. It's been in business for over 100 years, and it's really hard to turn down those offers to convert that farmland. And so, again, I mentioned we're having to get creative with conservation efforts, and that's part of it, is we're just trying to increase communication between potential developers and, potential entities that want to come in on land and the farmers, just so the farmer has kind of a clear snapshot of what's going on or could be going on in their community.
Well, very good, and appreciate your letting us know more about your organization, and I wish you all the best. Thank you for being here today.
Thank you, sir.
Anything further from Mr. Neese? Commissioner Justin Williams?
Good afternoon, Mr. Neese.
Good afternoon.
Thank you for the work you do for farmers. I just have a question. It's really coming from a place of curiosity. When I go home and I drive through North, Neeses, Orangeburg, Blackville, Williston, Rich Spring, Sally, and places like that, I've noticed a lot of what I call solar farms. And they're pretty big, and I can remember as a kid that they did not exist. Before they were like row crops or trees, but something other than the large solar farms. Is when you talk about developing farmland, are you as concerned about the solar farms as you are about those other developments, or is there a difference?
It's kind of a complicated issue because oftentimes what we encounter is with small farms, they tend to be diversified farms, meaning they're not just growing cotton. They're not just growing peaches. They're growing 15, 20 different things. And with commodity farms, it's not always the case. And so one thing we run into is, it's a complicated issue when it comes to solar farms because land that has solar farms on it, oftentimes you're not able to farm that land. Especially when you leave a solar farm on just a piece of property, it tends to decrease the value of that property. Usually, not always, but usually. And so most of our farms, they may have kind of like an auxiliary or kind of a complementary solar farm operation off on one side of their property. But a lot of those large solar farms that you'll drive by, those are commercial operations. Farms don't have anything to do with those. It is sitting on viable farmland. And again, it's often hard to farm land that's consumed by a solar farm. But again, it all just kind of depends on the size of the development. I mean, oftentimes we tell our farms to diversify. When we say diversify, we don't just mean crops too. We mean agritourism. Have events on your property. Work with local school districts to bring school groups in. Just really find new ways to bring income into your property. And small-scale solar farms often are a part of that. But no, when you start looking at these large-scale solar farms, that oftentimes does gobble up farmland as well.
Thank you for sharing that perspective. Your agritourism must have reached down to Sally, South Carolina, because my family has lived in that area for about 200 years. And here recently, somebody opened up a petting zoo that draws people from all over the place. So I don't know if you ever heard of it or not, but that agritourism thing is a pretty big deal. So thank you for that.
Yes, sir. And one thing you'll find is a lot of that started after COVID, because with COVID, a lot of our smaller farms, if they sell to restaurants, well, when the restaurants closed down during COVID, they lost their income stream. Or if they supplied farm-to-school contracts and the school districts closed down, they lost their farm-to-school contracts. So farms had to get really creative with finding ways to bring people on their property to just supplement their income in any way they can. And, petting zoos, they're popular.
Thank you very much, Mr. Neese.
Any further questions for Mr. Neese? Mr. Neese, thank you very much for your testimony this morning. We appreciate your time and interest in this matter, and you may stand down. You may continue listening, or you may sign off. If you continue listening, I ask that you please mute your microphone.
Thank you all.
Thank you. Ms. Boyd.
All right, Madam Chair,
you go.
there we are. Thank you so much. So I just wanted to inform you, Madam Chair, that Ms. Hemingway, Ms. Marilyn Hemingway, did appear online earlier. I think she had another obligation. Ms. Elaine Cooper was present in the hearing room, and she did inform me during the break that she had another obligation, and she will file her written comments via contact at psc.sc.gov after today. Ms. Boatwright also had appeared virtually. I don't see her right now in the WebEx queue. However, Ms. Queen and Ms. Queen Goodwine, if I mispronounced your names, please, I apologize in advance. Ms. Queen Quet Marquetta Goodwine is ready to provide comments virtually.
Thank you. Ms. Goodwine, can you hear me?
Yes, ma'am. Good afternoon.
Good afternoon.
Yes, Gladys Padilla, commissioners and things like that. I the Queen Quet, head from the body of the Gullah Geechee Nation. I done yeti on the children cracky deep plenty to the vote we done yet thing like that because I done yeti but the low country of farming and all that all this your time I've been there from the line. So to help y'all in your recorder, I will speak in this language instead of my native tongue, which is Gullah Geechee. I am the chiefess and head of state for the Gullah Geechee Nation. I'm also the founder of the Gullah Geechee Sea Island Coalition and a founding member of the Gullah Geechee Fishing Association and the Gullah Geechee Sustainability Think Tank. And so in regard to the latter, we have a great deal of concerns about keeping resiliency of our coastal region here in South Carolina and ensuring that cultural heritage communities are able to thrive and survive. Being a native Gullah Geechee from historic St. Helena Island, Palawana and Dato Islands in Beaufort County, South Kakalaki, as I like to say, I know that our families have focused on maintaining our land ownership. In particular, since 1862, I am sitting on a piece of property right now that on one side of my family, we've had the deed since 1862, and on the other side of my family, just across the waterway, we've had the same thing there. And so when we talk about people coming onto your land, whether this is a utility company or an individual just wanting to dig up your soil to place something in it, that's problematic for us, not having knowledge of what it is that they're doing, not having prior informed consent as an internationally recognized, quote, minority group as it pertains to us, end quote, in international law, but also simply as land rights, water rights, cultural heritage, and human rights advocates and people that defend this. And so I salute your commission for having the vision, the foresight, to have an opportunity for those of us from the public sector to know, number one, that your commission exists, because many of us in what is now deemed the BIPOC communities don't know you all even exist. We don't even know that there's a body like yours that helps to talk about this type of regulation. And I heard Commissioner Williams, I heard him very clear, the male Commissioner Williams, I heard him very clearly being concerned about whether or not this body is the right body to put forth these regulations. Well, I pray you are, because I encourage you and any legal team that you have to definitely implement this Bill of Rights. And I would suggest that you work with every county in South Carolina to make sure that this Bill of Rights has to go out if a utility company wants to come on to new land, to inform people about the environmental impacts that they will have and the cultural community impacts that they will have. And they can easily do this in collaboration with counties, because every one of us in South Carolina that owns land, you know we pay property taxes. Therefore, there's no complications. I'm a computer scientist. There's no new coding that has to be done if they work in conjunction with the counties to have some sort of public sessions, public hearings, public education sessions to build capacity and education around what it is that they would be bringing in. So especially in regard to natural gas, I was very concerned about talking about pipelines because I'm one of the folks in my organizations that were previously mentioned fought off offshore drilling coming to our state and coming throughout the Gullah Geechee Nation, which runs from Jacksonville, North Carolina to Jacksonville, Florida. So when we hear the term pipeline, it brings up a lot of additional things in our minds. And then we need to be able to make the connection between this, your commission, utilities, and so forth that operate within our wonderful state of South Carolina, which is supposed to be the place of beautiful places and smiling faces. And I know you would love some smiling faces that are not like the song Smiling Faces when you're doing the work that you do, because I have to sit in the seat to hear a lot of public comment many times, but I'm very pleased to have the opportunity today that you are getting to hear these comments from me on behalf of the Gullah Geechee Nation in support of you making sure that going forward that there will be prior informed consent from people before any utility company, not just if it's a gas pipeline, is going to lay a pipeline of any kind on people's land and through communities, because many times historically it has then cut out the heart of what is the black community, what is the indigenous community, and we especially don't need those hearts bleeding all over our beautiful palmetto here in South Carolina. The blood is already at the roots of South Carolina's palmetto because of what happened that brought my ancestors here. So I would hope that we stop that and we put some triage on things that are causing a lot of people pain. And so I definitely appreciate all the previous testimony that support the work that you all are here to do to help South Carolina be the wonderful palmetto state that it is. And being someone who has received an Order of the Palmetto Award, I feel it's an order that I get to talk to you today. So I want to say thank you to all 100 children. Thank you for this opportunity to present before you.
Queen Goodwin, thank you for your comments. Hold just a second and let me see if there are any questions.
Like what you drink. Yeah, good wine.
Good
He is
wine.
not silent.
Thank you, ma'am.
Chair
Commissioner Carolee Williams.
Thank you. Queen Quet, it's really wonderful to see you again, and I really don't have a question, so I'm going to do this very quickly, but please tell the other Carolee that I'm thinking of her.
I will, definitely.
Any further questions?
Madam Chair.
Commissioner Irvin.
Thank you. Queen, I appreciate your appearance today and taking the time to share your thoughts and concerns with us. It's a beautiful background. Where are you now physically located?
I'm physically on St. Helena Island today.
Well, it's a beautiful background, and I know you agree with me that we need to keep it that way, right?
Yes, sir. I have been fighting for that. I spent almost all of yesterday evening at Beaufort County Council fighting for that once again to protect our cultural protection overlay district for St. Helena Island, the only zoning law in the world that I found to protect the culture. So I pray that you and others up there would also help us down here on the coast.
And, you know, I think it's a wonderful thing that you're trying to preserve and protect your culture, your native culture, your language, your traditions. How many members of your group exist now? How many do you have? How many members do you have?
Do you mean citizens of the Gullah Geechee Nation? Well, I'm a computer scientist and a mathematician, so I always give this caveat. It was over 25 years ago when socioanthropologists attempted to do this count, because the Census Bureau does not allow for a specific count for Gullah Geechees. So they skewed the numbers when they said it was 500,000 at that time just between Carolina and Georgia. As a mathematician, when I checked what they used, I was like, well, they were off totally. There was at least 1 million at that time between Jacksonville and Jacksonville, much less South Carolina and Georgia, and South Carolina being a large concentration and Georgia being a larger concentration of us. And so we have multiplied since then. So we don't have yet an accurate count. What we encouraged people to do on last census was to check other and write in Gullah Geechee so that at some point in time, the U.S. can catch up to us. But that is always kind of my caveat, since we don't have a specific head count. And as Native Gullah Geechees, it's something spiritual and cultural that we don't like to count heads as well. So that's an issue too.
I understand, and thank you for giving us that history lesson and the background. I'm wondering if you ask your congressman or your United States senator to inquire about why the Census Bureau will not give you place on their form.
We haven't asked them specifically, but now you've given me some more work to do. I didn't know I was coming here after this work to do more work, but I appreciate it. So I would definitely ask them specifically. And in fact, it's interesting you mention that, because I now have been working with the Department of Commerce, and they had some census folks there at a meeting that I was at last year. So I may actually have a direct contact to the Census Bureau now that I didn't have prior to maybe 6 to 9 months ago. So I'm going to also inquire about that when I go back up to D.C. this summer directly with the census folks and see what they tell me, because I did bring that up at that meeting. Yes.
I think our congressional delegation of South Carolina owes it to your folks. You know, let's get an accurate count. You know, that's important. I know that may be against some of your beliefs, but it would help us in other ways to know. Don't you agree?
Yes, I do agree with you. I do agree with you, especially at such a critical time as this, and especially in regard to issues like what we're even here to discuss. I think that is critical to know that. So I appreciate you for giving me homework. I'm a straight A student, so I usually do pretty well in class.
May God bless you and your work. Thank you for joining us.
Thank you. Thank you. The same be unto you.
Commissioners, any further questions for this witness? Hearing none. Quinn Quett, thank you for your patience this morning. First of all, I know you didn't anticipate it being quite all morning before you got to speak, but thank you for your comments, and we appreciate your participation in this morning's proceeding. You're welcome to stay online and listen to the remainder. If you do, I ask that you mute your microphone, or you may be excused. It's at your pleasure. Thank you, ma'am.
Thank you so much. I've learned a great deal today, too, so it was worth the wait. Thank you so much.
Thank you, ma'am. Have a good afternoon. Ms. Boyd?
Yes, ma'am, Madam Chair. There aren't any other virtual witnesses on the WebEx line or in the hearing room at this point, so.
Okay, thank you very much. I think we've reached the point where I know that, I can't remember who asked that the legal argument be bifurcated from the testimony of and comments as we go through the regulations, and we did not bifurcate it because the hearing date was set by state register, and we felt that everything needed to be in one day or one proceeding on the days noticed in the state register. But if council is ready, we will go ahead with the to hear from you on the legal issue that has been raised in this proceeding, and we will go this. If we all are okay, we'll go in the same order that we have the parties listed as Dominion, Piedmont, Santee Cooper, Duke Companies, Southern Environmental Law Center et al., South Carolina Office of Regulatory Staff. Is that okay? Dominion Energy, Mr. Anselmo.
Thank you, Madam Chair, members of the Commission.
Is that on? Try again.
Sounds like it's on.
Yeah.
Sounds like it's on?
He's controlling it from the back.
Gotcha. I'll try to get as close as possible. Talk a little louder. Thank you. Dominion welcomes the opportunity to present our comments on Subarticle 9, the pipeline regulation.
We filed previous iterations, so I'm not going to belabor that, but I do want to hit some high-level points that I think are very important for the Commission to consider as we move through this. As some of your questions have alluded to, there is a question of jurisdiction or authority in this case for the Commission to act on property-related issues such as what's encompassed in Article 9. This Commission only receives its authority by that given to it from the General Assembly. And what the General Assembly has done in regards to property matters and eminent domain specifically is made a policy decision not to vest you with authority in this matter. In fact, the General Assembly is pretty clearly, as clearly as I've seen them do it, expressly and unequivocally reserve those powers for itself. They created Title 28, Chapter 2, the Eminent Domain Procedures Act, where they not once but twice in Sections 28-2-60 and 28-2-210 said that act is the exclusive process for the issues raised in the proposed regulation. Also notably is the process is supposed to be uniform. It is supposed to be the only process by which entities with eminent domain power and property owners resolve the differences, purchase the property, and go through the court process and the notice process, which we'll get back to. The uniformity is key because there's been some allegations that there has to be an alteration or addition to the Eminent Domain Procedures Act in order for you not to have jurisdiction. That's not the case. Uniformity is what it means. It has to be exclusive and the only process by which the state adjudicates these issues. And if the statutes themselves aren't clear enough, the General Assembly in 3 years, 2015, 2016, and 2018, addressed this issue in the context of pipeline regulations. And I can't say it better than the General Assembly. It is the duty of the General Assembly to establish the policy for the authorization of use for eminent domain and to provide the statutory processes and procedures to balance the interests of the state's health, safety, welfare, and the property of the state's citizens without unnecessarily impeding or discouraging economic development. Now, as I mentioned earlier, they did that. They established the process. It's the Eminent Domain Procedures Act. It's not a very short process. It's an entire title of the code. I've litigated some of these cases. There are robust due process protections in the act. It makes recommendations for the landowner to get counsel. You get to avail yourself to the full panoply of litigation options and discovery, motions, trials, and appellate review. And what's particularly relevant, I think, to some of the comments from earlier today about the transparency and the notice to landowners, there's a specific section in the code, 28-2-280, that specifically tells the entity trying to condemn land the notices they have to give to landowners. It's a robust list of things. That's say whose behalf the property is being taken on, what they're seeking to take, maps, rights, appraisal rights, counsel rights. It's an exhaustive list. I won't read them all. It's a rather long section, and it spills over into Section 290 if the landowner elects to do the non-appraisal panel option. So there are significant options and due process rights for landowners. And the trigger for the entire eminent domain process is set forth in the section 28-2-70. And what it is, it's communication. You start talking to the landowner. That is the trigger, the communication. And why that's particularly relevant here is what this proposed regulation says in subsection B, is the utility can't even start communicating with a landowner whose property might be affected by the proposed pipeline until they complete everything set forth in subarticle 9. So what the subarticle is doing is disregarding the process that the legislature set in place, delays it perhaps for an indefinite period of time, and changes what the legislature did. It's not exclusive anymore. You've created a new process specifically with the communication regard. And then also, subsection I, again, implicates what I just talked to you about. Subsection I, the Bill of Rights that we've heard some stuff about, it's already encompassed in the Section 280 that I just mentioned to you under the Eminent Domain Procedures Act. In order to maintain uniformity, you need one notice. The legislature's spoken on the issue of notice, and it's covered in the Act. Also, I think some of the comment letters had mentioned that you could perhaps draft around the lack of authority that the commission has by not holding hearing or merely receiving information. But the General Assembly has almost contemplated that already and has said in another section, 28.2-120 of the Act, that any statute, rule of civil procedure, or other rule that affects the Eminent Domain Procedures Act fails. So if the rules of civil procedure in the court system in which the Eminent Domain Procedures Act exists can't even alter the procedure, the regulations of this commission can't do the same. And then lastly, I think it's important to note that these aren't necessarily my ideas. This commission has, in fact, already agreed that it lacks the jurisdiction to deal with these specific issues. In 1992, y'all issued Order 406 addressing easement and property issues related to, in that case, telephone lines, but the issue is the same, and held, the commission concludes that while a utility may be subject to the same basic principles of property law as any other entity, the enforcement of these property laws is not within the scope of the commission's regulation of utilities. In fact, as a creature of statute, the commission only has authority to regulate rates and service. Y'all reiterated that in 2007-753 as well. And I think that's an accurate finding, especially when your power to regulate the utilities and promulgate regulations isn't unfettered. It's tethered to the authority that the General Assembly gives you. And in fact, in 58-3-140, under the powers to regulate public utilities, there is a subsection E that makes it clear that nothing in the section, your promulgation of regulations, may be interpreted to repeal or modify specific exclusions from the Commission's jurisdiction pursuant to Title 58 or any other title. Simply, you don't have the ability to change state law. The policy decision has been made, and we ask that the Commission reject the proposed sub-Article 9. Happy to answer any questions that you might have.
Commissioners, questions for council?
Madam Chair.
Commissioner Jay Williams.
Council, my question is pretty simple. Considering everything you just said, I'm struggling to figure out how the sections that are questioned regarding jurisdiction were able to even come before us. My understanding is that there's a stakeholder process and there's a lot of communication and back and forth. Were these issues not discussed then? And I had the same question for all the lawyers, but since you're up first, it's going to start with you.
Commissioner Williams, there was a stakeholder process. There were several iterations of the proposed sub-Article 9, and in each instance, the utilities have been pretty consistent, as have other parties, other certain parties, that the authority or jurisdictional issue has been present and should have ended the process. However, it is admittedly, it's, I don't know how to phrase this. It's been a robust process, and I've actually found the back and forth to be very beneficial, but the fact of the matter has remained pretty consistently that there is no jurisdiction or authority. I think it was worth exploring to make sure that everybody understood that, and I think it has helped at least me understand certainly that there is no jurisdiction for the Commission to act here.
Thank you. Sure. Thank you, Madam Chair.
Thank you, Commissioner. Further commissioners, questions from commissioners?
Madam Chair.
Commissioner Irvin.
Thank you. Council, thank you for the history lesson and the recitation, and you make some compelling arguments. But my question is, rather than us arguing or speculating about what is or is not within the purview of the Public Service Commission's authority, wouldn't a court of competent jurisdiction have to make a determination as a matter of law, rather than just kind of rely on orders? You were saying y'all, well, those orders that you were referring to were entered many, many years ago, and none of us were on the commission at that time. I dare say you weren't even out of law school at that time. Is that probably true?
see, the first one, no. Second one, yes. I was clerking for Court of Appeals judge on the second one.
Good for you. So as a good appellate lawyer, what do you say about my question? Isn't that a question for the Supreme Court of South Carolina to ultimately decide?
Respectfully, Commissioner Irvin, subject matter jurisdiction and authority-related questions are specifically to be addressed by the tribunal in which the party is asserting jurisdiction. It is first determined at that level. So whether it be this commission, another regulatory agency, a master in equity, a circuit court, those questions are first housed at whatever entity in which jurisdiction is asserted to. So in this instance, you would need to pass on that question, and then if there was subsequent review of that, it would, of course, by statute now move to the Supreme Court directly.
Well, you're a good student of the law, and I congratulate you on clerking with the Court of Appeals. Which judge did you clerk with, by the way?
Kay Hearn, when she was chief judge.
Well, she was certainly a good one, and we whether you agree with all of her decisions or not, you have to admire her intellect and her work ethic. So let me ask you this: don't you think that it would be helpful if we had a Supreme Court decision that addresses this specific question of law?
I don't think it's a question that requires appellate intervention when the answer is clear. I always prefer a Supreme Court case, of course, but I didn't find it necessary to find one when the statutes themselves were unambiguous and clear.
Well, that's a good answer, and you're a good lawyer, and I expected as much of you. Seems like Dominion gets the best lawyers. I don't know how that works, but they really have a great legal team, I'll tell you. They're always several steps ahead of the rest of the pack. But back to my inquiry, you would agree with me that there is no Supreme Court case in South Carolina that addresses this issue, this jurisdictional issue, would you not?
Well, I haven't researched it in depth enough to know the answer to that question, but I'm happy to look and provide supplemental authority if there is one.
I would like to know the answer to that question. So I want to ask you to research that issue. I think we all need to know. Has this question of law ever been addressed by the highest court of our state? I think you'll find the answer is no. But if you find it's otherwise, would you please let us know? And of course, you know, the ex parte rule means that you have to not only let us know, but you have to let every member of the docket or their legal representatives know before you communicate. So I understand you know the rules, but just as a general reminder, if you would, Chair, can we leave the record open for a reasonable period of time to receive that?
Commissioner Irvin, the record by statute will stay open for 5 business days following this proceeding for additional comments to be filed, and so we will ask counsel to make a filing either alerting us or telling us there's nothing there.
Yeah, either way, counsel, could you let us know within the statutory 5-day window?
Certainly will, and just again to reiterate, when I often have argued statutory interpretation questions at the Supreme Court, the first question, of course, as you know, Commissioner Irvin, is whether the statute is clear and unambiguous, and if it is, the inquiry ends. So I just reiterate that the inquiry here on the General Assembly's intent is not even intent, it's a clear enunciation that the exclusive and uniform procedure is the Eminent Domain Procedures Act.
Well, spoken like an excellent lawyer, and I certainly appreciate your opinion, but I'm looking for a Supreme Court opinion, not an individual attorney's opinion. So look forward to hearing from you. Thank you so much.
Certainly.
Commissioner Caston?
Good afternoon, Mr. Hazelmont.
Good afternoon.
Let me ask this way. Do you think any type of reports should be provided to the commission or ORS with any condemnation action, or what do you think the commission should do?
I think to the extent that any of the activities of a utility fall within the Siting Act or are also sought as cost recovery in a rate proceeding of some nature, then that information should in fact be provided and has been provided to the commission. But the discovery process inside of the Eminent Domain Procedures Act allows the landowner the same protections that any other litigant would have, and from experience I can tell you they utilize that process and utilize it well, so they can have every bit of information that is help them inform their decision and work out a resolution of the action. And I should have caveated all my statements by saying that none of the utilities enjoy using eminent domain. They'd much rather have an amicable resolution of these situations. But to the extent it gets to the point where there has to be some sort of resolution, the Act provides for that and allows for the exchange of information that's necessary.
Thank you very much.
Mr. Anselmo, good afternoon.
Good afternoon.
We're talking pipelines here. Has the commission been vested, to your knowledge, with any authority regarding the siting of pipelines?
I think I might have you cited the wrong statute. The statute is cited in our, I believe, April 6, 2021 letter. I just can't remember off the top of my head which one I was referring to. I have a feeling Mr. Ellerby or Mr. Jeffries is going to clean that up for me in about 2 minutes. So don't hold me to the Siting Act one.
Well, I mean, but you're familiar with the Siting Act under the commission's jurisdiction?
Yes.
Does that apply to natural gas pipelines?
No.
Okay.
No. There's another statute that I'm thinking of that's cited in our letter that I apologize.
That's okay.
Just completely blanked.
And I wanted to, you mentioned in your comments about some legislation or something with the legislature in 2015, 2016, and 2018. Could you clarify that for me?
Yes. So I don't know if y'all recall, it was in the news, there was some question on whether certain out-of-state for-profit pipeline companies had the power of eminent domain under the Act in order to run a pipeline in.
And when you say the Act, you're talking about the Eminent Domain Act?
The Eminent Domain Procedures Act, yes, ma'am. And the Attorney General at the time did an opinion letter opining that it was his opinion that it did not, the companies did not have that authority. And in the preamble of 3 acts, Acts 205 of 2015, Act 304 of 2016, and I think my handwriting says Act 156 of 2018, the General Assembly verified, sort of acknowledged that is the correct interpretation of the Act, and then used the language that I said earlier, that it is their duty to establish the policies and procedures for eminent domain.
But if my memory serves, those that Attorney General's opinion dealt with petroleum pipelines.
That's right.
Is that correct?
That's right.
Okay. To your knowledge, is there anything comparable to the Siting Act dealing with electric generation or transmission lines? Is there anything comparable giving this commission jurisdiction over natural gas pipelines?
I'm not familiar with any statute that would allow y'all authority over where natural gas pipelines go.
Thank you.
Mm-hmm.
Commissioners, anything further from Mr. Anselmo? Commissioner Thomas.
There we go. Can you hear me?
Yes.
Thank you. I believe that I heard you say something to the effect that we, the Public Service Commission, only have authority to the extent that something ends up becoming part of a rate case or rate base or covered as an expense in a rate case, something along those lines. Can you repeat what you said there? Help me understand.
Yeah, 2 separate things that I spoke to that could possibly interrelate. If the General Assembly gave you power over something, regardless of what it is, as long as it's constitutional to pass it to this commission, you would have authority over it. So carve that out. I think Commissioner Caston asked me the question regarding when an instance would be where a utility would have to give you information regarding gas pipeline. It was in the context of cost recovery is the correct answer to that question.
So cost recovery means?
A rate case or a general rate case, potentially an RSA proceeding, anything involving the gas utility where they're trying to recover the cost for that.
So I guess just trying to take that to the next step. In a rate case filing, we potentially could or would have information as to the costs that a gas utility has expended in connection with one of these eminent domain cases.
Yes, sir, and you would have the opportunity, as you do in all those proceedings, for parties to present evidence and determine whether those actions are reasonable and prudent and would allow cost recovery.
Okay, thank you.
Anything further? Mr. Anselmo, thank you.
Thank you. I don't know how to turn this off, so I'm just going to.
Yeah, they're controlling it from the back. We've had a break in the sound system, so they've jury rigged one in here. So let's see, where's my list? Mr. Jeffries or Mr. Richardson? For Piedmont.
Thank you, Madam Chair.
Sorry.
My apologies at the outset. Some of this is going to sound familiar to you, I think, based on Mr. Anselmo's presentation. I appreciate the Commission's indulgence in allowing me to speak for Piedmont today. Piedmont has filed multiple sets of comments in this docket as well as in the predecessor docket, 2020-247-A. My presentation today is not intended to address every single argument we've raised in those comments, but I did want to note that we have not abandoned any of those arguments simply because I don't discuss them today. From Piedmont's perspective, Sub-Article 9 establishes what is essentially or proposed Sub-Article 9 establishes what is essentially a pre-clearance system for new pipeline construction by a regulated natural gas utility in South Carolina, and it restricts both the manner and the timing of a utility's right to initiate eminent domain procedures with potentially impacted landholders. The pre-filing procedure requires development and filing of significant and I would argue burdensome reports, including a very broad environmental impact analysis, which includes analyzing the indirect impacts of natural gas construction on sprawl and development that could result from pipeline construction. It also requires the conduct of an environmental justice study, along with a determination as to whether the area where the proposed pipeline would be built is served or can be served by electricity to provide the service that would be provided by the proposed pipeline. This procedure under the proposed regulation will take at a minimum 120 days from start to finish, but that does not include the significant amounts of time it will take the LDC to develop the required reports. And during this period, under the proposed regulation, the LDC is precluded by Sub-Article 9 from communicating with landowners regarding eminent domain matters. Sub-Article 9 also defines and restricts what information may be provided to potentially impacted landowners, and as just noted, when it may be provided. The timing requirement and the content restriction of Sub-Article 9 directly and unavoidably impede and interfere with the structure and intent of the Eminent Domain Procedure Act. And by way of comparison, under the Eminent Domain Procedures Act, the South Carolina Code, Section 282-40, explicitly provides at any time before or after commencement of a condemnation action, the parties may agree to and carry out, according to its terms, a compromise or settlement as to any matter, including all or any part of the compensation or other relief that is at issue in the proceeding. Obviously, the ability to communicate is a predicate to the ability to negotiate or compromise or settle an eminent domain claim. Therefore, the significant restrictions on communications with landowners that are set forth in proposed subarticle 9 interfere with the natural gas's utility rights specified in the Eminent Domain Act. Further, Section 282-70 of the South Carolina Code, also part of the Eminent Domain Procedures Act, places an affirmative obligation on a natural gas company to make diligent efforts to settle a condemnation matter before filing suit. So subarticle 9 interferes not only with the rights of a natural gas company to engage in discussions with landowners, but it actually interferes with the company's affirmative obligations under the statute as well. As Mr. Anselmo noted, in several places in the Eminent Domain Act, it provides the exclusive procedures for condemnation. It also provides that the Eminent Domain Act shall prevail over any other law of South Carolina that conflicts with it. And it's important that the legislature anticipated the possibility of conflicts over the exercise of eminent domain and expressed an intention that the procedures that the legislature established in the act establish a uniform procedure for all exercises of eminent domain in this state. As Mr. Anselmo said, subarticle 9 will defeat that intent by creating non-uniform procedures applicable to natural gas companies. And as a result, there will not be a uniform set of procedures to be pursued with regard to the construction of natural gas pipeline facilities. Based upon these facts, Piedmont would respectfully submit that the proposed subarticle 9, which seeks to impose pre-clearance procedures before Piedmont or any other gas company can consult with or negotiate with or attempt to resolve any condemnation claims, it cannot be approved by this commission because it is in direct conflict with statute. Thank you.
Thank you, Mr. Jeffries. Commissioners, questions for Mr. Jeffries? Thank you, Mr. Jeffries.
Thank you.
Appreciate it. Mr. Pelcher, do you have comments on this issue?
Thank you for recognizing me. Sandy Cooper supports the arguments that have been put forth by Dominion and Piedmont attorney here today regarding the authority of the commission to promulgate proposed Article 9. We really have nothing to add beyond what they have articulated. Thank you.
Thank you, Mr. Pelcher. Duke Energy Carolinas and Duke Energy Progress.
Thank you, Madam Chair. Frank Ellerby for DEC and DEP.
Mr. Ellerby, before you get into it, can you adjust that microphone? Thank you, sir.
Is this better?
Yes, sir, I think so.
Okay. I'm going to, we support the arguments that have been advanced by Piedmont Natural Gas and Dominion regarding the statutory authority issue. And I will try my best not to repeat the arguments that have been ably made by Mr. Anselmo and Mr. Jeffries. There is one thing I'd like to emphasize. The Chapter 2 of Title 28 is the Eminent Domain Procedures Act. I happened to attend a CLE, Continuing Legal Education Seminar, back in the late 1980s, at which a presentation was made by Judge Goolsbee, Burt Goolsbee, who at that time was in the Attorney General's office. He had been involved in negotiations that led to that legislation being passed, and he explained, I had forgotten this till I was reviewing it in connection with this regulation. He explained that the state had a lot of different procedures for eminent domain actions in different contexts, different condemning entities. And the focus of the Eminent Domain Procedures Act was to unify and create one procedure that everybody could follow and could understand and would protect landowners and would allow condemnation to move forward. So the whole point of the act was to create a uniform procedure that would be followed. What is in proposed subarticle 9 would subvert or undercut that process by creating a different process that would apply to 2 companies in South Carolina. It would apply to Piedmont and Dominion, but it wouldn't apply to all the other natural gas companies that are not regulated by this commission. So that's exactly, in my experience, my understanding, exactly what the General Assembly intended to eliminate by having a uniform procedure for condemnation proceedings in this case. The other thing, we also agree with the argument that the subarticle 9 would essentially be, in essence, a siting act for gas utilities. And the General Assembly, as y'all are well aware, has adopted the Siting Act for electric utilities. It applies to major electric utility major facilities. It does not apply to gas pipelines. So we think those are reasons why this commission should conclude that it doesn't have the authority to adopt subarticle 9 and should not send that to the General Assembly. The other thing I wanted to explain to y'all, and it's a little bit of a policy argument, but I'll make it brief. The reason that the Duke companies, the electric companies, are appearing, and the reason that we care about this is that Duke has, in its IRP, most recent IRP filings, has 4,740 megawatts of additional incremental natural gas generation that is planned through 2037. Now, as y'all are well aware, that is subject to change, but that's really important. That natural gas generation is really important as the company transitions its generation fleet and retires coal generating facilities. We think that subarticle 9 would inject uncertainty, there are potentials for protracted litigation in subarticle 9, and that would create uncertainty about whether natural gas generation could be brought online in time to be in place to provide dispatchable generation so that coal plants could be retired. That's just the kind of uncertainty that we don't need to be dealing with as y'all address your responsibilities in the electric utility planning process and move forward. I will note that as the subarticle 9, the provisions were originally proposed to y'all, there was a proposal that the commission would hold a hearing, and the commission staff, I believe, revised that, and so now there is a provision of a forum. So it's not, I think the intent of that change was that there wouldn't be a contested case hearing on the application to approve the pipeline project, but instead there would be a forum held. However, there is a complaint process that's still called out in subarticle 9, and folks that do not agree with what the company has done or that would have the complaint process as a vehicle to contest whether the company had met all of the requirements in the reg in subarticle 9. A complaint would turn into a contested case proceeding, and there would be a right of an appeal. There's also a provision in the Eminent Domain Act that a landowner can contest a right to condemn and bring an action under the Eminent Domain Procedures Act to contest a right to condemn, and a landowner would potentially be able to argue the gas utility didn't comply with the provisions of Subarticle 9, and therefore that gas utility doesn't have the authority to move forward and condemn. Lots of opportunities for litigation, lots of questions, and some of the comments that have been filed in this docket point out some of the ambiguities and inconsistencies in Subarticle 9. Those are ripe for litigation, and any litigation is going to involve delays. That's a major concern of electric utilities that need to be able to have a consistent planning process to move forward with natural gas generation as we move forward. So for those reasons, we think the Subarticle 9 is not a good idea. It's also, as indicated, beyond the authority that has been granted to this commission. I'll be glad to answer any questions if y'all have any.
Commissioners, questions for Mr. Ellerby? Commissioner Ellerby, the complaint procedure, did that make it into the final proposed reg that you mentioned?
There is the very last thing in,
okay.
you see
About
that?
the complaint procedures, yes, I see that. I was keying in also on the 30 days after service, the landowner may file an action in circuit court, and I took that to be, that part to be the note included in the notice of the customer's bill of rights under the eminent domain.
Well, it's unclear.
Okay.
But I mean, that last part,
I see that now.
If anyone believes that a gas utility, which
right,
might even mean that you just have to have a belief in order to have standing. So
may not be an affected landowner.
Might be somebody who has a belief that the the utility didn't follow every requirement. So it's one of the things that we could resolve with some litigation. So
okay. Thank you. Nothing further from me. I think we're Mr. Holman.
I've discovered as I get older that your hand-to-eye coordination drops by 50% when you stand up before a microphone, so let me get my papers sorted first.
And Mr. Holman, I'm going to ask you to adjust that mic and be able to try to talk into it. Like I said, we had a little glitch with the sound system, so we're a little jury-rigged today.
Well, can you hear me now?
That's better. Thank you, sir.
I often have this problem with my height and the microphone. So I'm going to ask you all to bear with me, if you will, because I'm the only lawyer, who's going to stand up and talk in favor of the landowners who are affected by this process. And of course, we've got a very able, well-established, talented group of my colleagues over here who have had the opportunity to speak the other way, and I suspect we'll hear some more negative comments later. And I realize we're all so late in the day and nobody's eating lunch. But this is the one opportunity really the landowners have for somebody, a lawyer, to speak in their favor. And there's several points that have been made today that I strongly disagree with, but of course, as a matter of politeness and procedure, I just had to sit there silently, and this is my opportunity to address some of the questions that have been raised. And it's also my opportunity to put this into context. And I won't tell you exactly how I got involved, but it'll reflect the context in which, the context that I present will illuminate somehow how I got involved in this. As you all know, I normally don't appear before the Public Service Commission. I think the only time I ever appeared here, nobody present was around, unless maybe Commissioner Williams was around. I don't think so. It was dealing with the coal ash challenges at Robinson and at the Lee plant on the Saluda River. That was a long time ago, and that has now been dealt with. But before I begin, I do want to thank the Commission and its staff for taking these issues seriously and for the first time airing them and taking them on. And that's why these rules and proposed regulations are so important. And let me emphasize what they do. They provide for transparency. They provide for information to the public, and they provide respect for owners of private property, our citizens, taxpayers, and residents of South Carolina. It would require that a private landowner be given basic information about his, her, or its rights before the condemnation process gets underway. We provide that kind of notice to accused criminals in this country. A basic fundamental statement of your rights before you are drawn into the process. Surely, it's not too much to ask to provide that to law-abiding citizens who are being drawn in without their request, without doing anything wrong, into a process that would seize, against their will, their private property. Now, let me put this into context because I think it answers some of the questions. This is a very unusual situation, as my fellow Frank said. It applies to two companies, and this answers some of the questions that have come from the commissioners. That's right. Because we face a situation with respect to natural gas pipelines that we don't face with respect to anything else. And that is that we have given the power of the state to come into your most private situation, your personal property, home, or farm, and seize against your will your private property without any approval, consideration, or review by any public entity responsible to the citizens and voters of the community where they live. Now think about that just for a minute. We have given the state's most coercive power over to entities whose decisions are made in Charlotte and Richmond over whether my property in Travelers Rest can be seized against my will without any review from any or approval from any democratically elected or accountable entity. So, for example, Greer Public Works, the citizens of, they're going to be dealing with the very people who elect the body, or who elect the body who appoints the body that they are being subject to seizure by. That's true of our sewer system, most all of our sewer systems, our water systems. So many, those are people who are working for democratically responsible entities who are dealing with the people who are their constituents. And they are subject to the Freedom of Information Act. And they're subject to accountability at the ballot box. That is not what we have here. This is a totally different situation. And as you have heard, and as I have seen personally, this is the first time I've been involved in this. This is in northern Greenville County. And I saw people who have graduate degrees and are very sophisticated business people And I saw, as one of the witnesses said, widows with limited education and everybody in between. And I can tell you they were all confused. Many of them, as Ms. Smith said, felt misled. There was no prior notice, no public explanation of what was happening or why. Just bam, dropped in the mail. Letter, we're coming to survey you on your property under these rules, blah, blah, blah. What's happening? What's happening to my home? No maps available. Nobody is telling us why, when, or how. And what are my rights? I mean, we hear all these talks about all these legal procedures sophisticated lawyers are familiar with. Most people don't deal with those things day to day. They never do. They find those intimidating and fear-inducing. And here it's not just legal matters. It's legal matters that involve an intrusion upon your most private rights and existence. You're, in the instance where I saw it, your church, your home, your farm, the farm that's been in your family for years, the home you just bought, as in case of Ms. Smith's family. Suddenly the whole situation is going to be changed. Here, the commission chose not to propose pre-approval for this. They don't have to get any, still under the regulation, they don't have to get anybody's approval. They can still go forward based on what's decided in Charlotte and Richmond. They don't have to get anybody's approval even under these rules. What you all have proposed is simply tell the public what you're going to do, what the impacts are, and let's notify individuals of their legal rights. A summary of their legal rights. Just a basic fairness and openness. Now, we've heard about delay. I can tell you, had Piedmont Natural Gas done this up front, they would have had a lot less delay. We spent a year, Ms. Smith explained part of it. We spent, according to my recollection, a year of uproar. People not knowing, having to fuss in the media, go to their legislators, contact everyone they could, never filed any lawsuits, to try to get information which was dribbled out. Finally, Piedmont had to just shut the whole process down and say, we're going to have to start it all over again, which happened again with limited and unsatisfactory public sessions. And ultimately, if all that information had been provided up front, which you know they have if you're going to spend that much money, you know you're going to do these kind of studies and have that information, all that confusion and all that time and waste would have been avoided. But perhaps as important, we would have avoided a lot of heartache. It is very easy for us sitting here in this room, in this calm environment, to speak of this academically. But that is not how those people felt it. For them, it was a life-disrupting event. It was a sleep-denying event. It was worrying about the future of your life event that went on for weeks and months and even years. That did not have to happen. And these rules that you have proposed would provide sunshine and information, as we all know, and as we have learned the hardest lesson in the regulation of public utilities in South Carolina. Nobody could have learned that lesson harder than we have. Sunshine and public information are the best disinfectant. In Oconee County, 3rd District, where I grew up, there was no saying there's no education in the second kick of a mule. Public information, sunshine, let everybody have the same information. It's available. Why not provide it? Now, let me talk about the legal issues that have come up about authority. And I'm going to tell you, this is, to me, the legal fact is exactly the opposite of what you've heard. It's not a question of whether you have authority. The statute could not be clearer that you have express authority to do this. The statute says, and I think Ms. Gibson or somebody actually quoted it, but it's worth quoting again because you couldn't say it any plainer using the English language. 58.5.210. The Commission has the power and jurisdiction to supervise and regulate the service of every public utility in this context, that means the gas utilities, and to ascertain and fix standards, classifications, regulations, and practices to be observed and followed by every public utility. That's exactly what we're talking about here. And you don't have to take my word for it, you can take your own word for it. They cite some not particularly relevant prior decisions. I can cite your very regulations. Go to Article 4, Gas Systems, Sub-Article 1, 103-400, Authorization for your rules. It cites the very statute I just quoted and says, in accordance with that provision, the Public Service Commission has adopted the following rules and regulations and has adopted the following standards. What is one of those standards? It's Rule 404, where you provided that no public utility supplying gas to the public shall hereinafter begin the construction or operation of any gas facility or any extension without first obtaining from the Commission a certificate of public convenience and necessity. The only reason we're here is that that provision includes some exceptions into which these particular kinds of pipelines fall. If they're saying you don't have authority to just require something much less than a certificate and necessity, then you don't have authority to adopt that regulation. But that regulation, by the way, was adopted in 2008. And according to my memory, I haven't double checked it, it was during an era whereas today the legislature reviewed rules. This went into effect with legislative review. If you didn't have the authority to, you could have even required under this rule, you could have required a pre-approval here for this line. You could have done that. You did much less than that. But if their arguments are correct, then you're wrong. The legislature was wrong. Your own article is wrong. Your own legal interpretation is wrong. This is your regulation. This is not mine. And the statute is not mine. It was adopted by the legislature. And I would say in this context, you not only have the authority, I think you have the responsibility, an obligation to take action. You've heard from numerous people, not just the ones who spoke here. We've had 4 or 5 different public hearings. And we've heard stories like these, and you've gotten, I think, more than 100 individual comments from people. And all they're asking for is to not be left in the dark. Don't just trust the utility in terms of information, but still, they can still go ahead even if we don't like it. They can still go ahead. Now, then the question is, oh, you've offended, it would offend the eminent domain laws to provide public information for these regulated utility privately owned monopolies that the legislature's expressly granted the commission the authority to regulate. That's the whole concept of these monopoly utilities, is that there will be adequate regulation. And somehow it offends the eminent domain statute to require public notice and information of what's happening. Not one word in this document changes any of the procedures that would be followed upon implementing eminent domain. If they're saying you can't have any requirement for any requirement for anything to be done prior to just an eminent domain proceeding, then I would say, as the chair cited, the Siting Act for electricity utilities. Well, how is that valid? It requires a procedure before eminent domain. They'd have to get the siting approved. How is your regulation valid? It requires a certificate of public convenience and necessity before they could undertake eminent domain. There is no word in the Eminent Domain Act that prevents this commission from carrying out the express authority the legislature gave it to regulate the standards and conduct of how the utilities interact with the residents before they begin to implement or undertake eminent domain. We heard the concerns of my friend from Duke Energy. Totally irrelevant. It's just really an argument hoping to tie into things you hear in your rate-making cases. This regulation expressly applies to a gas utility defined as one that provides public gas services to the public. That has nothing, Duke Energy doesn't do that. They don't do that. And furthermore, certainly the gas pipeline that's going to provide huge quantities of natural gas to their power plants, it doesn't do that. This rule has nothing to do with the creation or operation or success of natural gas generation of electricity. It has nothing to do with it. I mean, I could just come in here and say, well, you know, we ought to be concerned about some other topic, and this might cause uncertainty. It has nothing to do with it. That's a totally separate, as you all well know, series of state and federal rules over the provision of electricity by power plants. This is about those two utilities in the state, really. If they were to split into three, there could be a third one, I suppose, that provide gas services to the public themselves, not an electric utility company that is obtaining natural gas in order to generate electricity. And if I could reply to a couple of the other points, there was allusion made to this legislation and in 2015, 2016, and 2018. That's the so-called Kinder Morgan controversy, where Kinder Morgan, a private petroleum pipeline company, not a regulated monopoly in South Carolina for this purpose, was wanting to put a pipeline up through Georgia into Aiken County, and there was a total furor about it, as you may remember, whether they were going to exercise eminent domain. And the question was, did a petroleum pipeline, totally different from a natural gas pipeline company, have power to exercise eminent domain? That's what all that dealt with. There's no question they have the power to the natural gas pipeline companies, these two, have the power to exercise eminent domain. That's not in dispute. That's a totally different and irrelevant issue. And by the way, your proposed regulation does not prevent them from sending information out. If you read it, it says no other material shall provide it in this transmission. In other words, a transmission, this is designed to provide the property owners notice of their rights, information about what's happening. They shouldn't be able to stick other stuff in there. This is an official notice. But this rule doesn't prevent them from talking in the newspaper, doing whatever they want to promote or explain this line. In fact, the point of the regulation is to encourage them to provide more information, to encourage more public information of what is occurring. And I guess it's obvious, but since it was suggested otherwise, we should respond to it. Under this rule and under anything else, you are not engaging in eminent domain. You don't do that. That's not, and this rule wouldn't have you do that. This rule is simply information provided to the public about their rights and about what is happening in this process. The condemnation notice provided in statute would not be affected. They still have to provide that notice. That's not an issue. And in fact, you have written this rule to expressly say it is not intended to and does not in any way affect the law of condemnation. So I would summarize this way. This is a crying problem. This is not something that can be explained away and say, oh, normally it's not a problem. It is a huge problem. We've seen it on the ground happen for a matter of years in northern Greenville County, and we've heard of it elsewhere in these various hearings we've had and the comments you've gotten. It is not it is a serious problem. There isn't, I would say it has been suggested that the Commission doesn't have the authority. To the contrary, I would say it is absolutely crystal clear the Commission does have authority. You cannot say it any clearer in the English language, and this Commission has said that itself in the past. If there is any question, as you know, there will be legislative review of this rule, and the legislature can react appropriately if there were a question. But in terms of what the legislature has told you in the past, to date, and what this Commission has done to date, is not only do you have authority, what you have seen here today and over the period of years is that you have a crying obligation to do it. And that's the result of that has been these draft regulations. And I would like to close again by thanking the Commission for, through these proposed regulations, putting forward again the principle of transparency, and at the same time recognizing the rights of individual property owners so that we will not repeat the bad situations we have had in the past under the current situation. Thank you.
Thank you, Mr. Holman. Commissioners, questions for council? Any questions? I think you've covered all your bases.
Chair.
Commissioner Irvin.
I got one quick question if you're still here. Still there, Mr. Holm?
He's still there.
Yes.
All right, just want to make sure. You know, after hearing you describe where we are, this those regulation in terms of transparency and accountability, it's almost unimaginable that a landowner would not be given prior notice that their property was going to be torn up, taken away, without any kind of notice or opportunity to be heard. That sounds to me like something that would happen in a communist country, maybe Soviet Union or the former Soviet Union. I mean, isn't that what Russia's doing to Ukraine? It just doesn't make any sense to me why we would not want full transparency and accountability. And what's the justification for not doing it? If we're wrong, the General Assembly, as you say, will have a chance to reject the regulation. If they're concerned about it, I'm sure they'll let us know. That's a further check and balance on our power and authority to issue regulations, is not?
Yes, absolutely.
And the General Assembly has competent lawyers and available to them to give them legal opinions. And I'm sure some of the folks that appear to us today, they have lobbyists that can affect the process. So it's not like they're being locked out of the State House. They will have their input as well, don't you think?
Oh, absolutely. I have, to some degree, seen that myself. They will be more than competent to do that.
In fact, it'll be an army of lobbyists going over there to object to this, will it not?
Right, absolutely.
And you know, when it comes to being transparent and accountable, I've always wondered why a monopoly needs lobbyists in the first place. If you think about it, they have no competition. They have free reign to in a service area. Nobody else can come in and compete. I'm kind of at a loss as to what are they over there for? Why do they need a lobbyist? The law is already in favor of the utility, just like the matter we're going to take up later today. The statutes were drawn by the investor-owned utilities. And there's nothing wrong with that. You know, and for the most part, they do a great job. They give us safe and reliable service. They make contributions to the community. They create jobs. So they do a lot of good things. But why are they so opposed to having landowners get notice that something's coming down your way? It's going to affect your property rights forever. What's the problem? Can you explain it to me? I don't get it.
Well, just to expand on that, we heard the suggestion, these property owners, okay, they can litigate with Piedmont Natural Gas or Dominion Electric. Now, I mean, if you go out in the real world and talk to human beings who own property and live in these communities and are our friends, neighbors, relatives, and fellow citizens, not only are they going to be confused by this process, not only are they not going to know how to navigate it or know what their rights are, if you tell them, oh, your solution is you can sue, litigate and sue with multi-billion-dollar monopolies who are some of the most powerful institutions in our culture, I mean, they will just laugh you right out of the community center you're having a meeting in, and for good reason. That's no solution to the issue we're talking about. We're talking about simple fairness, common sense disclosures, giving law-abiding citizens the same information we give somebody when they get arrested, and just to be able to know what is proposed for their property and their community. And we're not even putting any limits on what they can do, what the utilities ultimately can do. So you know, too often we have to fight obvious battles. So that's the only way I can explain it. At this point in my life, I've learned sometimes you have to fight things that seem to be so clear. Why do we have to fight over them? But here we are. And this is not a path I started out on. I didn't aim to be here. I just started out helping people in northern Greenville County who a pipeline was going to be put through their property without knowing what, why, who, or where. And here we are today. But I'm thankful that we are here today and that the commission and its staff have taken this issue seriously.
Thank you, Madam Chair. No further questions.
Thank you, Commissioner Irvin. Commissioner Justin Williams?
Sure.
I just want to thank you for your passion. I can sense your frustration. The only thing I really can say in response is welcome to the show.
Thank you. I guess we all live the show. Thank you.
Commissioners, anything further for council? Mr. Holman, thank you very much.
Thank you very much.
Appreciate your participation in today's proceeding and your comments. Anything further regarding the legal issue of jurisdiction? I'm sorry, Mr. Mustian. Excuse me. Officer Regulatory Staff.
Madam Chair, I'm used to being overlooked, so I take no offense.
I apologize.
And I know the hour's late, so I will be brief.
Well,
I
we're
did,
not through. We got a ways to go yet.
well, I didn't know what our lunch plans were, but in any event, I did just want to make a couple of comments. Mr. Holloman did start off his comments that he was the only one speaking for the landowner, and I certainly understand the context in which he said it. But I did want to just take the opportunity to say, you know, we certainly respect the sensitivities of private landowners. We understand when landowners are going through condemnation proceedings how difficult of a procedure that can be. And certainly our comments should not be taken as minimizing those concerns at all. Our concerns are the same as those echoed by the utilities, really with respect to the authority of the commission in its ability to promulgate the Article 9 in the regulations. So I won't belabor that. I won't repeat what's already been said. We have filed our letter saying that we agree with the utilities position in that regard. In addition, you're aware that we filed a letter on March the 13th of 2023 outlining basically some questions as we presented it that we it was really meant as food for thought as to the proposed regulations, how it would work. So again, I won't belabor that, but just wanted to make those brief comments. Happy to answer any questions that the commissioners may have.
Commissioners, questions for Mr. Mustian? Any questions? Mr. Mustian, regarding those March 13th comments, it was is it correct that I'm reading it that ORS is of the opinion that the statutes don't give jurisdiction to the commission to promulgate the proposed regulation in question?
Yes, Madam Chair. We did state, just to quote from the letter, that we submit that absent action from the South Carolina General Assembly granting additional authority to the commission to regulate natural gas pipelines, the requirements and procedures set forth in 495 exceed the current statutory authority. So yes, ma'am, that would be correct.
Okay, thank you. Commissioners? Thank you, Mr. Mustian.
Madam Chair, can I just ask one question?
Commissioner Irvin?
Thank you. Mr. Mustian, you're very familiar with the legislative process, and you would agree that if this regulation is adopted, the first thing that will happen is that it will go to the South Carolina General Assembly for their review, approval, or rejection. Is that your understanding of the process?
Commissioner Irvin, that is my understanding. I do believe in the APA there were some provisions about addressing questions of the authority that first must be addressed by the agency. So I do think that it is incumbent upon the commission to determine whether or not it does have the authority. But yes, I would agree with you that assuming the commission does adopt and promulgate this regulation, that it would go to the General Assembly for them to review and ultimately decide whether or not it should be implemented.
Thank you. No further questions.
Any council, any comments, further comments on the legal issue before us today? Okay. We need a quick break for our court reporters. I think her voice is about to give out on her. But let's take 5 minutes and come back at 2:05, please. Good afternoon and welcome back to the Public Service Commission as we continue the proceeding in docket number 2022-360A. Let's check in with our commissioners. We have Commissioner Irvin virtually, and in the hearing room we have Commissioner Justin Williams, Vice Chair Powers, Commissioner Thomas, Commissioner Carolee Williams, Commissioner Caston, and Chair Belser. Council, for the parties, we're at the point now, I think, where we will go through the individual regulations to see if there are comments, concerns, objection on any of the wording. We will go section by section listed, and I'd just like to get everybody's comments per section rather than have each party stand up and address all comments at once. It just makes it a little easier in my review, so I'm imposing that on everybody else. Ms. Boyd is going to lead us through that. Council, if you would, please feel free to speak up and say, I have an objection, or I'm good, and we'll just go down the line if we can, starting with Dominion, Duke, Piedmont, Southern Environmental, Upstate Forever, and ORS. So if you're fine with it, you can just say okay, or if you have an objection or a concern, please raise it at that time. Everybody got a copy of the PowerPoint presentation?
Madam Chair, we have a slide.
Thank you.
Some slides to share with you regarding today's rulemaking. Please, ma'am. All right, we're ready. So the statutory authority, as you're aware, the commission staff has been reviewing the commission's regulations pursuant to South Carolina Code annotated section 1-23-120J. And for this particular hearing, today's public hearing, the notice of drafting was published on November 25th, 2022 in the State Register, and the proposed regulation was published on January 27, 2023 in the State Register. And today's public hearing was noticed in that register. There's a list of, on the next slide, you see a list of the regulations that were included in the commission staff's proposed regulations that were published in the State Register. The first one dealing with Regulation 103-402, and you've seen this where staff has proposed that the commission include local office, business office in the electric systems proposed regulations on the last public hearing you had. And we've done the same here to add definitions for local office or business office and for mail, as those terms are referenced in other places in Article 4.
Parties, any comments on adding the definitions of local office or business office and mail?
No objection from Dominion.
No objection from Duke? No comment from Piedmont?
Nothing
No
here.
comment from SACE?
No comment.
No comment from ORS. Thank you.
The next section, Madam Chair, is the title of that regulation is Location of Records and Reports. And this the proposed changes to the regulation would require all records to be maintained by a utility under the gas systems regulations either within South Carolina or in an accessible cloud-based or other electronic records retention system, and that those records be available for inspection by the Office of Regulatory Staff or its authorized representative. And there's also one change from the word to make the reference neutral.
Which reference?
In G. Nope.
We're in
No,
410.
I've moved on to 430.
We're in
I
410.
apologize. Right. It's just what I've mentioned. There aren't any gender neutral reference changes in 410.
With regard to Regulation 410 and the amended language,
No objection from Dominion?
No objection from Duke, no objection from Piedmont. No comment, no objection from SACE, and no objection from ORS. Thank you.
Regulation 103-430, customer information. The proposed change here allows utilities to post their rate schedules on each utility's website and in each local office if one exists. And there's also a gender neutral reference in section little g that's been changed.
Okay. Also in 430C, there's a or for download.
Yes, ma'am.
Okay. With regard to the proposed changes to 103-430, subsection C and G. Okay from Dominion, okay from Duke. Piedmont, no issue. Mr. Holman, no issue. ORS, no issue. Thank you.
Okay, the next regulation, 103-431, governs customer deposits, and under A4, there's a gender-neutral reference that has a recommended change there. Also in 5, new language has been proposed where a utility would be allowed to require a customer deposit from a non-residential customer or parent company that is experiencing financial difficulties as determined by the gas utility's internal credit risk rating criteria. There are some tools there that the utility can offer or use to obtain that deposit from the non-residential customer. On the next page, well, page 7 of the document that we distributed earlier, there's a new section B that basically states if the gas utility requires a deposit from a non-residential customer, the utility has to notify the affected customer of the provisions of this rule. The old section B has been struck because it relates to prospective customers, persons who aren't, or entities who aren't customers yet, that they have to be notified of the provisions of the existing customer deposit regulations. On the next page, Madam Chair, I know we've already...
Wait a second.
Oh.
We're on 431.
Right,
There's
and I'm still, Madam Chair, I'm still on 431. Not on that, yeah. I just wanted to point out, because I failed to do so for the electric systems regulation, some orders, and I realize this is the gas utility regulation public hearing, but there are some orders that I have on the next slide that I think are the language that's being included for the gas systems regulations looks a lot like what's been proposed in the electric systems regulations. And what the commission decided in the most recent order, which would be the 2009 order regarding certain, allowing electric utilities to require a customer deposit based on the customer's credit worthiness and other internal rating criteria that the electric utility uses. The commission on page 11 of its order 2009-770, and I realize this is this order relates to electric utilities, but I think the language is similar. It says that the partial waivers that were granted in order 2009-770 for similar language for electric utility regulations basically would remain until the commission could promulgate regulations. So I just wanted to point that out. That's all I had to say, Madam Chair.
Mr. Anselmo.
Chair Belzer, as the commission recalls, a couple weeks ago we met for the Article 3 regulation changes. And in 103-331, Lockhart Power had proposed pulling certain language out of sub A5 and having a new sub C. I should have brought this with me, so I apologize I didn't. But the intent there was just to eliminate the confusing nature of when the utility could offer alternate credit arrangements. And when the gas companies, or at least Dominion, proposed some revisions to 431, we wanted it to mirror 331. And because 331, perhaps, depending on your ruling, will be changing slightly, Dominion would at least recommend that the changes to 431 mirror those in 331.
All right, sir. Mr. Anselmo, do you anticipate filing something within 5 business days of the close of this hearing?
I do now, yes.
Okay, that would just be very helpful to clarify it. I'd had a note about the change in the electric regs. I couldn't remember that it was exactly 331, but
We'll submit a letter.
that would be very helpful.
No problem.
Thank you. Anyone else? Comment from Dominion? Anything from Duke? Anything from Piedmont? Both indicate no. Nothing from
Well, no,
Mr. Holman, ORS.
No objection to what Ms. Boyd has discussed, and I don't anticipate any problems with what Mr. Anselmo is proposing, but would just ask that he provide us with the proposed language just so that we can review in advance of that 5-day period expiring.
Thank you. Not a problem. Mr. Anselmo indicated not a problem, so. Ms. Boyd?
Yes, ma'am. The next slide, slide 10, relates to Regulation 103-433, and this is interest on deposits. So the proposed language is amended to clarify when interest on deposits cease and the mode to communicate to the customer that the interest on the deposit is stopped.
Okay. Any concerns with 103-433 subpart C edits? Nothing from Dominion, nothing from Duke, nothing from Piedmont, nothing from SACE, nothing from ORS. Thank you.
The next regulation, Madam Chair, 103-436, deposit retention. A new section has been added regarding a gas utility's ability to retain a deposit of a non-residential customer or its parent company if those entities are experiencing financial difficulties determined by the gas utility using its internal credit risk rating criteria, and/or if bankruptcy may be imminent, even if the customer continues to make bill payments in a timely manner.
With regard to the amendments, it's a new section B under 436. Any issue or concern from Dominion? From Duke, none. Well, from Dominion, none. From Duke, none. From Piedmont, none. From Southern Environmental, and I apologize, Mr. Holman, I've been calling you SACE, and it's Southern Environmental, so excuse me.
That's a high compliment. They're a lot more knowledgeable than I am.
No comment from Southern Environmental, no comment from ORS, shaking his head.
The next regulation, Madam Chair, is 103-439, customer billing, and the proposed language would require utilities to include the telephone number and email address of the Office of Regulatory Staff on customers' bills. And you'll recognize the same language that I used in the electric systems regulation public hearing, just a recommendation for the commission regarding information to include in its order related to the Office of Regulatory Staff, Consumer Services, email address, and telephone numbers.
And we are not, I just want to be clear, we are not putting the email address and telephone number in the regulation. It's just that ORS would keep the utilities current on their current email address and
Yes, ma'am.
and telephone number. Okay.
Yes, ma'am.
With regard to the amendment to 103-439K, any objection or issue from Dominion? None. From Duke indicates no. From Piedmont indicates no. Southern Environmental, no.
No objection.
And ORS indicates no.
The next regulation, 103-440, adjustment of bills. There's a misspelled word willfully in number 2, where it says customer willfully overcharged. We just added an L there in the caption. And also in the sentence, it begins reading, if the gas utility has willfully, you'll notice that under an extra L that's been included.
So is it spelled correctly in the amendment?
I hope so, Madam Chair. Should be.
Well, spelling has never been one of my strengths, but okay.
Yes, ma'am. Also, we struck the language provided in SC Code and Section 585370/1976, and would like to replace that, or we propose to replace that language with the provisions of SC Code annotated Section 34-31-20A. Also, and I'll review that too in its entirety, or such future code of laws if that code of law section changes, governing the legal rate of interest of cases of accounts stated, and in all cases where any sum or sums of money shall be ascertained and shall draw interest according to law. There's another section impacted the equal payment plans. So we struck the language, the difference between the actual and estimated annual bill must be resolved by one payment to officially allow utilities to work with the customer if need be, if the customer needs more time other than just one payment for the true up. And then in number 6, at the end, right before the colon, under this section 6 reads customer undercharge due to human or machine error. We struck the language that would require the gas utility to recover deficient amounts and included the permissive word may instead of shall.
Okay. All right, this one, we got to unpack a good bit here. With regard to the changes in Regulation 103-440, subsection 2. Wait a minute, I got them all. Shouldn't fold the pages back. Subsection 2, correcting 2 misspelled words of willfully, and then referencing a code section with regard to the legal rate of interest. And then in 5, equal payment plan, striking a language requiring one payment, and then making 6, permissive rather than mandatory use of the word may instead of shall. Any concerns from Dominion?
No, Dominion's fine with all 3.
Thank you. Any concerns from Duke? You're fine with all 3, indicate yes. Piedmont indicates fine with all 3.
No.
Southern Environmental Law Center indicates no concern here.
No concern.
And no concern from ORS. Thank you.
The next section, 103-495. Gotta flip back to it, Madam Chair. Construction and/or extension of pipelines. This would be a new section to provide procedures when a gas utility intends to construct and/or extend a pipeline into an area where it does not currently have a pipeline, or if a gas utility intends to construct and/or extend another pipeline in an area where it has a pipeline. And you'll notice in the succeeding sections, Madam Chair, they slides, there's question and answer about the public comment forum that is in the new section E. And I have some questions here if you want me to just review what I've done here related to the public comment forum in the proposed regulation.
Just quickly go through those, Ms. Boyd.
Sure, I will move swiftly. So the first question, when would the commission hold a public comment forum? Basically, if the commission orders a forum after receiving a request from a member of the public, and the request must include the need for the forum, the number of residences and or businesses impacted, the environmental impact, and the financial impact on the community. The next question is, when would the public forum ordered by the commission be held? After the gas utility files the information contained in 103-495A. It would also, the forum, if it is ordered by the commission, will be held no sooner than 60, no more than 90 days after the utility sends the notice to each property owner through whose property the preferred route or alternative route would be constructed. What happens at the public comment forum, the gas utility would have the opportunity to make a presentation concerning the proposed pipeline. Persons attending the forum could submit written and oral comments to the commission at, before, and after the public comment forum, and could ask the utility representative or representatives questions attending the forum. And then finally, what happens at the conclusion of the public comment forum? The commission would basically provide a transcript of any and all written comments provided to the commission, the comments and presentations at the public comment forum. And that transcript would be posted on the commission's website and docket management system.
Thank you.
Yes, ma'am.
Oh, my screen went dark. It took me a second. Any comments from Dominion? Any further comments, shall I say?
No, we rest on our previous arguments on this subsection.
Thank you. Any further comments from Duke?
Nothing in addition.
No further comments from Duke. Any further comments from Dominion? Excuse me, Piedmont.
We'll rely on our file comments on this section.
Okay. And it's not only your arguments today, companies, it's your filed comments as well. Any further comments from Southern Environmental Law Center?
I'm afraid some people in the room might throw something at me if I made any more comments.
Mr. Holman, I want you.
That's enough.
I want you to feel like you've had
No,
adequate.
You have.
Okay.
We have.
That you've had adequate opportunity.
All right.
I don't.
Absolutely.
I know we're kind of pushing through because we've got this commission business meeting, but I don't want. We are prepared to come back after the business meeting. I don't want anybody to feel like they have been short-changed on time.
No, forgive my humor.
No, no.
We've already we've said what we want to, and we sent written comments also.
That's fine, but I just want the record to be clear that everybody, you've had your time and we haven't cut you off. That's what I want to ensure. And Mr. Mustian.
Madam Chair, we refer to our previous comments and our filed comments.
Thank you. Ms. Boyd?
Madam Chair, I don't have anything else.
Excuse me.
Oh, I apologize.
Commissioner Carol Lee Williams has a question.
Thank you. My question is to the companies. A lot of what we heard today is just good exchange of information. And I understand the arguments about, this is a regulation, but can anybody help me understand why you wouldn't offer much of what is included in this section just as a choice of being good communicators, good stewards? I'm getting a lot of blank stares, and so I think this is probably just one of those. I'm curious. We don't always do everything we are legally have to do. Sometimes we go beyond and communicate better. No one looks like you want to answer this question.
I'll jump on that.
Thank you.
Somebody, would you get a microphone, Mr. Jeffries?
I'm sorry, it's hard for me to speak while I'm sitting down. I'm old school that way. I think the first comment I would make is that, at least from my client's perspective, and the other utilities may have a similar reaction, we're somewhat stuck with the proposed regulation that we've got, right? So our comments that we've reacted to today are based on that regulation. There's not another variation of it or anything like that before us. So we've reacted to the regulation as proposed, and hopefully we've made our points on that. I would say, there was some discussion earlier today about the Greenville extension line that Piedmont initially proposed, and that generated a fair amount of unhappiness with landowners in the upstate region of South Carolina. And the project, and as a result of that, the Piedmont ultimately took a step back, reevaluated their proposals for the project, and that project is now either under construction or has been constructed primarily along public right-of-way. And so ultimately the concerns of the landowners were eliminated through the rerouting of that project. I will tell you anecdotally that I think Piedmont has learned from that experience, and there was never any intention on the company's part to operate in the dark or in secret or not share information. They were following what I think is probably typical of most public utility practices. When you are looking at building a greenfield project, you go out and you hire land agents and the folks that go through that process. And in this case, it didn't have an ideal impact on the folks that were going to be impacted. And we kind of got past that. But I can tell you on behalf of Piedmont that they are not opposed to the idea of communicating. I think they are, and again, I think whether they would be okay with a particular regulation or not would depend on what that regulation says. I think there is some consternation and some hesitation about expanding the process into a community referendum versus communicating with landowners that are impacted. I mean, there are different things that go along with the scope and scale of that sort of thing. But in principle, I don't think Piedmont has an issue or is overly concerned about trying to keep the fact of a project or the scope of a project secret.
Madam Chair, can I?
Um,
Oh, go ahead. You guys. Dominion has something.
Mr. Burgess with Dominion.
Thank you, Madam Chair, and thank you, Commissioner Williams, for your question. And I certainly don't want it to be lost on this commission that Dominion Energy constructs or extends its existing facilities in secret. That is absolutely not the case. The company engages in communications with the landowners with whom it is required to interact with when constructing and extending its facilities. They, in addition to notifying them of the project, they also hold meetings with the local communities explaining the routes that were considered, the routes that have been selected, and there are also numerous other requirements that go along with siting a pipeline, which we've discussed with y'all in prior, I think it was about maybe a couple years ago now. We've talked with y'all about that, where there are permits and other agencies who are involved in these types of matters. So I certainly understand the general concept of it's my land, you can't take it, completely respect that. However, there are instances that the greater good is required in order to ensure that we have economic development for South Carolina. And the Eminent Domain Act, and Council was right who said that earlier, I can tell you from experience, the absolute last thing the utility wants to do is to initiate a condemnation action against the landowner. Typically, those don't end well at the end of the day. So it is imperative upon the company, and they will try everything in their power to resolve the issue before it even gets to a condemnation action. But there are instances in which that's the only thing you're able to do, because the landowner, for valid reasons, I'm sure in their mind, conclude that they're not going to sell their land, or they believe that the value of the property is much more than that which is being offered by the utility. So I just want to make sure that y'all had an appreciation for that there's a lot of stuff, and that's not a very good legal term, a lot of stuff that goes on with respect to communicating with landowners to explain to them what is going on when it comes to constructing or extending a pipeline. So I hope that helps answer your question, Commissioner Williams, because these are things that there are folks who are inside the company, and they wrestle with this on a daily basis as to how to go about doing this in the right way. And I can tell you from experience, there's a lot of thought and consideration that goes into these projects. And not only that, you should know that in addition to constructing projects, we do an internal environmental justice analysis of the program to make sure that low-income communities or communities who may be impoverished don't bear the unnecessary brunt of economic development just because they happen to be in a low-income area. So we rank those accordingly, and that goes into the calculus with respect to constructing and extending pipelines in our service territory. But at the end of the day, as Mr. Anzomo indicated, the General Assembly has prescribed a process for us to follow, and that's the one that we think is appropriate to follow in this instance. So thank you.
Thank you, Mr. Burgess. Mr. Holman?
Yes.
Commissioner Williams, I can tell you from experience that is not the way it works. And that's why this regulation is so important. Can you hear me? And let me just give you some examples. This was before you all were on the commission, but Duke Energy proposed to put a huge power line from Ash. Can you hear me?
It's working.
Yeah, can you hear me now? Duke Energy, you may remember, proposed to put a huge power line from Asheville, North Carolina, down through the horse country of Spartanburg County and through the Blue Ridge Escarpment of Greenville County. And the first approach the utility always takes is what I call the science fair approach. That is, they come to a community center, they put booths around, and the people are expected to go and just talk to each one, but nobody gets to hear uniformly what is said. And I've walked around and you hear different things at different times, and different people interpret things differently. And it was a huge crowd showed up at that, and they revolted against this process. It was a huge controversy. And finally, this very commission, this is part of where this regulation comes from, this very commission went and held an open forum at the Landrum High School. There were probably 500 to 700 people in that auditorium. And this commission allowed people to state their concerns, raise questions, etc. at that session, much like what we're talking about here. Secondly, I was involved in all the coal ash fights in North Carolina. We went up to a place called Marshall on Lake Norman. Duke Energy and DEQ, the state agency, was going to hold it again, another science fair. 700 people were there. Fire marshal had to nobody could come in without somebody leaving in a public auditorium. And finally, the crowd said, we're not going to tolerate this. And they went up and got the microphone and said, we need to have an actual presentation and an opportunity for everybody to hear what everybody's saying. And after that, the North Carolina Department of Environmental Quality did that, and for every subsequent coal ash hearing in North Carolina, they did it the way the public wanted. With Piedmont Natural Gas, and let me say first, I met and got to know casually the local Piedmont Natural Gas staff in that area. Great people. No criticism of any human being. It's just the process, the way the process is handled. As was pointed out, they just dropped these letters on people, had a huge furor. Well, they said, okay, we're going to do better. It wasn't just one line change. They had multiple line changes the first year. Different crowd of people getting upset. Finally, they just said, we just got to stop the process. So they said, we're going to be more transparent. Well, their idea of transparency, of course, this was during COVID, but it was a forum virtually, but let's assume it was in person. And each person could ask you had to submit the questions ahead of time. When they read the questions, they rewrote them cosmetically so they wouldn't be as pointed. And you're sitting there listening to it. And then when they gave an answer, it was transparently obvious to everybody listening that they were reading answers written by a combination of the legal and PR staff. And you could imagine how frustrating that was, because what the citizens wanted was a real interchange. Tell us, really, where is this thing going to go? Who's it going to impact? We want to know those answers. And these weren't people screaming at them or anything. This is a very polite crowd. But afterwards, I would say the having learned, which we were told by Piedmont Natural Gas, what they did afterwards made people even madder. So that's why it's important that there be a standard that is much like what this commission did before. And that is, have one situation where people can ask questions, the utility can present the case, it may be so very persuasive, whatever. People get to ask questions and know the information ahead of time so they can ask meaningful questions. And everybody hear the same presentation, the same questions, and the same answers. And all this talk about, oh, it's fine, we talk with them, that's okay,
That's not the way it has worked to date, even after all this controversy. And I would say, too, I realize there's often not litigation under condemnation, that was mentioned. Well, of course. But it is not an even field. The citizen knows when he or she is talking with the land agent or the representative of the huge business, they've got the stick of eminent domain in their hand. And of course, most people say, well, I can't fight City Hall. I can't fight somebody's got the power of eminent domain who's a billion-dollar company. And of course, they rarely have litigation. But that's not because it was nice. That was because of the relative bargaining power in that situation. So here, we don't alter that, your rule does not alter that at all. All it does alter is knowledge and information. So the citizen will have more knowledge, property owner, of his or her or its rights, and will also have more knowledge of what's going on. Thank you.
Mr. Hallman.
Madam Chair, before you close.
May I go first, Commissioner?
Yes, ma'am.
Mr. Hallman, I have a question for you. You mentioned the Duke line up around Landrum coming down. That was the commission has electric siting authority, does it not? And
now you're counting on me having very good legal recall with my old brain.
Subject to check, would you agree with me that the Siting Act gives the commission authority to cite transmission lines?
I have to tell you, as I recall it, and I can't remember the legal permutation, but there was some reason why that line, as I recall, was not going to go directly through the commission for approval.
Okay.
And all the commission held was a public forum. It was a public forum only. It was not, as I recall, any kind of real hearing per se. It was an opportunity to give the public a chance to talk. And there had been great demands for that. And the legislators had asked for something to happen. Okay. That's the way I remember it today, that there was some reason why that provision didn't apply. Maybe because it was an interstate line. I don't know. Because it was going from the Asheville plant down.
I have a feeling we're getting ready to have an explanation, but do you want to go ahead, Mr. Commissioner Williams, or can Mr. Ellery respond to my question?
Whatever you instruct.
Mr. Ellery, can you enlighten me a little bit on that?
I'm glad to, Madam Chair. That was a project that where the company's engineers were considering a line, as Mr. Hallman suggested, from Landrum, in the Landrum area up to Asheville. And there were several different routes that were under consideration. And the company notified the people on all of the various routes that there was a consideration of putting a line in. The transparency that Mr. Hallman's been talking about. We had not yet filed a Siting Act application at the time of the public forum that was requested by the ORS asked the commission. There was so much interest in it as a result of those communications that went out about the various alternatives. There was so much interest in that area that folks got in touch with ORS. ORS asked the commission to schedule and hold a public forum, and a docket was created to have the proceedings in. We had not yet filed a Siting Act application, but we were going to, and we had to. And the plan was to do that. And ORS knew that. But we had some preliminary discussions, as Mr. Hallman suggested. That was all because of the Siting Act. So all of that process was part of the company's process leading up to trying to locate the transmission line in a place that there would be less opposition. But it ended up generating more opposition. So there are lessons learned on that proceeding, but it was completely transparent, and we never got the opportunity to file the Siting Act application. The company ended up making additional making alternative arrangements in North Carolina to get the project.
Well, I appreciate that clarification. I was kind of thinking that it was like a customer hearing that we would have in a rate case but the commission had just done that in the Siting Act. I did not remember all the particulars.
The commission, ORS and commission got ahead of the companies before we got to file the application.
Thank you. Commissioner Justin Williams, you had a question?
Thank you, Madam Chair. Counsel for Piedmont. Sir, I understand Mr. Anselmo's position and Mr. Ellaby's position, but correct me if I'm wrong, but when you say we are responding to the regulation in its current form, it leads me to believe that you may have an alternative approach to, I believe it's subsection 9, that encompasses what Mr. Hallman and whoever he or everyone he represents would want to see exist. And my understanding is that there's no prohibition from you filing a proposed regulation of your own or edits or anything that you think the commission should consider at this point.
There we go. I'm afraid you may give me too much credit, Commissioner Williams. We do not have an alternative proposal. I was simply pointing out that the regulation that's been proposed is problematic from my client's perspectives, and I think from the other utilities' perspective. And I was also trying to indicate that Piedmont appreciates the sensitivity of these issues among landowners upon whose property they propose to put their facilities. And as Mr. Burgess indicated, we fully understand why people would prefer that utility infrastructure not be placed on their land. And as is the case with Dominion, Piedmont is in the same boat, that they exercise eminent domain as a very last option. But the point that I was trying to make is that our comments to date have been designed to address the regulation as it's been proposed, and I don't want to get dramatically beyond that, because I don't have authority from my client to do that. So I'm sorry if I led you down the primrose path on that one. I didn't intend to.
No need to apologize. I just wanted to clarify. We don't have the authority to do it. I understand that very clearly. So if that's your position, I just want to make sure that I understand that. And I'm understanding that's your position. That's our position. Thank you.
Madam Chair.
Mr. Holman.
If I could just reply briefly. We had, there was Commissioner Williams, at the very beginning of this, the commission's involvement, there was, I'm not going to use quite the right word, but it was like a virtual forum about the Northern Greenville County situation. And some commissioners were on that, and you may have been. But at that time, the way I heard it at the time was Dominion and Piedmont were a little bit different, as you just heard, and that was that Piedmont indicated they were opposed to pre-approval by the commission, but they were open to maybe didn't have a great problem at that time with or at least open to, you have to listen to their exact language because I'm going by memory, the public disclosure provisions. But then after it got back to being briefed by lawyers later, they have taken the position they were against those too. But at the first public hearing kind of thing, it wasn't a public hearing, it's called do you remember the phrase for that? Well, it was before the workshops even. It was at those two the first video proceeding. At least I heard an openness to Piedmont for the disclosure provisions. But when it was briefed legally, it's true, they opposed them.
Thank you, Mr. Holman. Anybody have anything else to bring before the commission on these regulations? And if you do, we can break and resume after the business meeting. But I just want to make sure everybody's had their say. Everybody had an opportunity. Okay. Gentlemen, thank you very much for your participation and your arguments and sharing of your clients' positions today. With that, we will leave the record open for 5 business days. If anyone needs additional time, you need to let us know. I think a couple of you may be filing some things with us, so we appreciate that. And then we will also have the comments that have previously been filed that are in the docket, as well as things that you've submitted today. So thank you very much. And with that, we will close this proceeding, but the docket remains open for another 5 days pursuant to the Administrative Procedures Act, 5 business days. Thank you very much, and hope you all have a good afternoon. Thank you.
Thank you.